hearing on wartime executive power and the surveillance authority of the National Security Agency with current and former FISA judges. Pennsylvania Senator Arlen Specter chairs the committee. This is live coverage on C-SPAN 3.
Good morning, ladies and gentlemen. It is 9:30, and the Judiciary Committee will now proceed with this hearing, captioned Wartime Executive Powers of the President of the United States and the Foreign Intelligence Surveillance Court. We will be hearing today from two distinguished panels. The first consisting of judges who have had extensive experience with the Foreign Intelligence Surveillance Act, four of whom have been on the Foreign Intelligence Surveillance Court, and the fifth, a key participant in the initial interpretation of the Foreign Intelligence Surveillance Act. This is the third hearing by the Judiciary Committee on this subject. Earlier this month, we heard from the Attorney General, and a second hearing, a panel of experts. And the central thrust of this hearing is to determine what judicial review, if any, should be accorded the electronic surveillance program which the President of the United States has announced. There is a contention by the administration that the Foreign Intelligence Surveillance Act was amended by the resolution authorizing the use of force on September 14, 2001. After extensive hearings, it is widely viewed that the Foreign Intelligence Surveillance Act has been violated. That is my view. Because the Act provides that the exclusive remedy for electronic surveillance in the United States must be preceded by a warrant of authorization by the FISA court, or, with an exception, 72 hours afterward on an emergency situation. There is a second issue as to whether the President has inherent authority as Commander-in-Chief, war powers, to conduct the electronic surveillance. That, as I see it, would require knowing what the program is. It may well be that the program is within the President's inherent authority, but it seems to me that that determination has to be made in accordance with the tradition in America by a court, by a judicial review. Our hearing today will take up the legislation which I have introduced, which essentially provides that the administration will have to submit the program to the Foreign Intelligence Surveillance Court, and the court will make a determination on constitutionality. The President says he is unwilling to share the information with the intelligence committees as mandated by the National Security Act of 1947 because Congress leaks. It certainly is true. But so does the White House. But the FISA court has an unblemished record of integrity and ability to maintain a secret, and they have the expertise to do the job. There has been recently created a subcommittee on the Intelligence Committee of the United States Senate None yet in the House. There's a controversy with some saying that they won't have a subcommittee because the statute says that the review should be by the full committee. So we will wait to see what happens. There has been legislation introduced by Senator DeWine which provides that the administration may conduct electronic surveillance without restraint for 45 days, and then at the end of 45 days, if there is sufficient evidence to go to the FISA court, they go there, but if there is not, then they go to the subcommittee of the Intelligence Committee. In my view, the subcommittee of the Intelligence Committee is no substitute for judicial review. These are obviously very, very weighty considerations. There is no doubt about the tremendous threat posed by al-Qaeda to the security of the United States. That is a given and recognized everywhere in the wake of the calamity on September 11, 2001. And we do need to be secure, and we want the President to have the authority he needs. But this is a shared responsibility, as the Supreme Court has made clear, that the President has extensive executive authority under Article 2, but the Congress has extensive authority in the premises under Article 1. And the arbiter under our system of laws are the courts, ultimately the Supreme Court of the United States. We have a very unusual panel here today. Judges who have experience on the FISA court, who recognize the importance of security and the importance of law enforcement, but also recognize the importance of civil liberties and the work which they have done on that court. Let me yield at this point to the distinguished ranking member, Senator Leahy.
Well, thank you, Mr. Chairman. I thank you for holding the hearing. We desperately need some answers to the basic questions about the President's decision to wiretap Americans on American soil without court approval, without attempting to comply with the Foreign Intelligence Surveillance Act. More than 3 months and 2 committee hearings after the President was forced to acknowledge the program's existence, this committee remains in the dark with regard to nearly every aspect of the program. As Senator Specter succinctly put it recently, we're still flying blind on a great deal of this. We had our first hearing on February 2nd with Attorney General Gonzalez, and his testimony was more obstructionist than enlightening. He flatly refused to discuss anything beyond those facts the President's publicly confirmed, nothing more. In other words, he wouldn't tell us anything more than what we just read in the papers. And the stonewalling has gotten worse since then. The Attorney General's, 3 weeks later, the Attorney General wrote an extraordinary letter to Chairman Specter seeking to alter his live, televised testimony, mainly by making it even less responsive. That letter raised serious additional concerns about the scope of the administration's domestic spying activities, his shifting legal rationalizations, and, of course, the Attorney General's own credibility. His letter admits that the Department's legal analysis has evolved over time. In other words, they had one reason when they started, changed the reason when it became public, and again refused to answer the basic factual question of when the administration came up with its theory that the congressional resolution authorizing a military force against al-Qaeda and the attempt to reach Osama bin Laden, the failed attempt to reach him in Afghanistan, authorized warrantless domestic wiretapping of Americans. I can only infer that their theory was concocted long after they decided to ignore the law. And in my 32 years in the Senate, I've never seen anything like this, ever. To fulfill our legislative function, we need to know what other invasions into American rights and privacy the administration believes were authorized and why, but they continue to stonewall. We received a response late last Friday to the priority questions we sent the Attorney General following his appearance on February 6th. Now, we got a response. We didn't get any answers, but we got virtually every question with some version of "we cannot answer," "we're not able to answer," "we're not in a position to answer," "it'd be inappropriate for us to answer." In other words, take a long walk off a short pier. We had a second hearing on this program on February 28th. That was an academic panel with scholars, and all is good discussion, but it's not oversight because they have no knowledge what's in the program. And our hearing today is somewhat the same. Our witnesses are experts in the Foreign Intelligence Surveillance Act, probably the best experts in the country. But they have no special knowledge of the President's program to wiretap Americans outside the Act. They can't tell us any more than the very little we already know what this, about what this administration has been doing under its theory of limitless executive power. So we have an impasse. We have an administration that says we have the power to do whatever we want to do. And actually, the Congress and the courts are irrelevant. That, of course, is nothing new from an obsessively secretive administration that has classified historical documents. Documents have been out in the public for years. And suddenly they yanked out of the archives and marked classified. They've conducted energy policy and attempted to outsource port security behind closed doors. They've routinely blocked investigations and audits. They've repeatedly harassed whistleblowers. They've dismissively refused to cooperate with congressional oversight for more than 5 years. They have a paranoid aversion to openness and accountability. They tell us, we won't tell you enough to do meaningful oversight of what we're doing, just trust us. How do we trust an administration when every day there's more evidence of its incompetence, including yesterday's revelation that our borders, even though they spend billions of dollars extra, our borders are not even secure from the simplest scheme to smuggle in a dirty bomb? How do we move forward to protect the security and right and freedoms of the American people? I think first, if the rule of law means anything, we have to insist on real oversight and real accountability. The chairman said we'll struggle to try to find out what the program is. We don't need to struggle. We have the constitutional right to compel information from this administration by subpoena. During the last 2 years of the Clinton administration, this committee approved the issuance of more than a dozen subpoenas to the Department of Justice and former DOJ officials, both for documents, including legal memoranda, and for live testimony. So the question is whether we can do the same thing when it's a Republican administration. And secondly, if there's a real need for legislation to ease existing restrictions under FISA, we should, of course, pass it, as we've done before, on a bipartisan basis, and we've done this with numerous powers requested by the administration over the past 5 years, but we shouldn't rush into that until we know what's happening. And finally, in discussing legislation, we should collectively draw a line. No new powers should be given to this administration until we secure a firm assurance they'll faithfully execute and abide by the laws as written. We've seen them say they won't do that in the Patriot Act, even though we passed it. They won't do it under FISA, even though we passed it. And as George Will pointed out, all those debates have been a meaningless charade if the administration's monarchical assertions of essentially unfettered presidential power are taken seriously. So we're not here to play charades. We're here to legislate the law of the land. And I think at the very least, before we legislate, we ought to know what is going on. Nobody in this room really does. Thank you.
Thank you very much, Senator Leahy. Before proceeding to the first witness, I want to read the first paragraph of a letter from Judge James Robertson of the United States District Court for the District of Columbia. Had been a member of the FISA court, and shortly after the surveillance program was announced, Judge Robertson resigned from the FISA court, leading to some set to say that he resigned because of the surveillance court, because of the surveillance program. That hasn't been confirmed by Judge Robertson, but he had been a member of the court, and he did resign, and that time sequence is a matter of record. And without objection, I'll put his entire letter to me dated March 23, 2006 in the record, but I want to read the first paragraph where he endorses the legislation which I have proposed to give the FISA court authority to review the electronic surveillance program. Judge Robertson writes as follows, quote, "Thank you for soliciting my views on your proposal, which I support, to give approval authority over the administration's electronic surveillance program to the Foreign Intelligence Surveillance Court. seeking judicial approval for government activities that implicate constitutional guarantees is, of course, the American way. But prudence in the handling of sensitive classified information, classified materials, suggests that only a limited number of judges should have the job. The Foreign Intelligence Surveillance Court is best situated to review the surveillance program. The judges are independent, appropriately cleared, experienced in intelligence matters, and have a perfect security record, close quote. We turn now to our first witness, who is Magistrate Judge Alan Kornblum. The 5 judges met with me briefly this morning and nominated and elected unanimously Judge Kornblum to be the lead witness, and that has been done because of his very, very extensive experience with the FISA court. The other judges will appear in alphabetical order. Judge Kornblum has an extraordinary academic record, a bachelor's degree from Michigan State University, a master's in public affairs from the Princeton University Woodrow Wilson School, a PhD from Princeton in 1973. Then he served in the Department of Justice, and from 1979 to 1998 served as Deputy Counsel for Intelligence Operations at the Office of Intelligence Policy and Review, and for the 2 years from 98 to 2000 as Senior Counsel, and during that time he supervised the preparation of more than 10,000 FISA warrant applications, and as I think easily the most experienced person ever on the issues of the FISA court. It is our custom, Judge Kornblum, to set the clock at 5 o'clock and 5 minutes. We had a long session yesterday. Before you begin your testimony, it is our practice to swear witnesses, so I'd ask you all to rise. Do all of you solemnly swear that the testimony you will give to the Judiciary Committee will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
May the record show that each of the judges has answered in the affirmative. Judge Kornblum, you have an extensive background on the FISA court, and you're going to be giving an extensive overview. And as I say, it is our custom to set the clock at 5 minutes, but we would expect you to take more time as you need it to give a full statement of the background and operation of the FISA court and the analysis of the pending legislation by Senator DeWine and myself. The floor is yours.
Thank you, Senator. I want to first express to you the humility that we feel, the 5 of us, and having the privilege to comment on this extraordinary proposed legislation. And I will be forthcoming and direct, but first I need to make 2 disclaimers. You should appreciate that we are not here to testify on behalf of the federal judiciary or the Judicial Conference, and we are not here to testify in any way representing the Foreign Intelligence Surveillance Court. I will take up 3 points in my introductory remarks: the importance of the FISA statute, the value of the proposal that you've made in the National Security Surveillance Act of 2006, and I will also take up the question of presidential authority to authorize warrantless surveillance of Americans. I would point out that I've carefully chosen the word presidential authority because I exercised that authority through a number of attorneys general for almost 20 years, and further disclaim that we will not be testifying today with regard to the present program implemented by President Bush. The main reason we're not going to discuss that program is because we've never been briefed on it, we don't know what it involves, and we're not in a position to comment intelligently about it. I'd also like to begin with our bottom line. Many judicial decisions begin with the court's holding, and so I'd like to tell you right up front where we come out on these issues. We believe that the Fourth Amendment permits the Congress to empower the President to seek judicial warrants targeting networks of communications of terrorists abroad used by persons who are engaged in international terrorism or activities in preparation therefor, which is the FISA standard, without having specific probable cause for all of those in the terrorist network, including incidental collection of U.S. person communications, balanced by stringent minimization procedures enforced by the FISA court. That is the sort of holding that we've come to and the position which I will argue in the next 10 or 12 minutes. I'd like to point out that I was very privileged in 1978 to be appointed by Attorney General Griffin Bell to handle all of the FBI and NSA warrantless surveillance applications and subsequently the Foreign Intelligence Surveillance Act. The purpose of our testimony today will be to assist the committee in legislating in this field. Because of my extensive experience in implementing the FISA statute from its inception in 1978 and my close working relationships with the FBI and NSA for more than 20 years, I am in a unique position to fully inform the committee. Fully inform is the statutory provision in FISA, which I carried out for a number of years as the Deputy Counsel for Intelligence Operations. And my presentation today is not going to be an academic discussion, but actually a discussion of my personal experiences. That is, I'm going to be testifying from the things that I know happened of my own personal knowledge. I'd like to begin by emphasizing one critical point. The FISA statute has been the most successful foreign intelligence program the United States has had since the code-breaking operations of World War II, the deciphering of the Japanese codes and the German codes. It has allowed the U.S. intelligence agencies to conduct intelligence activities beyond what they ever expected and to succeed in many ways which have never been revealed, because in the intelligence business, your success is measured by the fact that these things are never disclosed. I've also been involved in litigating more than 80 cases involving the FISA statute, and that also came to the Office of Intelligence Policy and Review, OIPR for short, and our office worked with the criminal division in preparing the briefs both for the district court and the appellate courts on issues relating to FISA. I was very proud of the fact that there were more than 80 district and circuit court decisions upholding the constitutionality of the FISA statute and its use by the FBI and NSA. In my experience, the success of the FISA statute has been due to the professional efforts of hundreds of FBI agents and NSA officials, of numerous Department of Justice lawyers, of 6 counsels for intelligence policy who I served under, and 8 attorneys general who I served under. And not to mention the 30 or 35 federal district judges, such as those before you today, who have served on the FISA court. I also want to emphasize that the real success of the FISA statute is that it's proven indisputably that intelligence and counterintelligence activities are fully enhanced by the rule of law and, in fact, are fully compatible with the rule of law. The final introductory point I would make is that the legal protections afforded to FBI agents and NSA personnel and all of the others involved in clandestine collection and counterintelligence activities is underappreciated by many people, but it is not underappreciated by the men and women working for the FBI and NSA and the other intelligence agencies in the field. Having said that, I'd now like to turn to Senator Specter's bill and discuss specifically some of the provisions and the constitutional framework why we believe that the statement I made a few moments ago about surveillance of communications networks, terrorist communications networks, is constitutional. As you know, the Fourth Amendment bars unreasonable searches and seizures, and the term unreasonable is the overarching concept. The substantive requirements of the Fourth Amendment are for probable cause and particularity. The standard of reasonableness applies to both substantive provisions. That is, what is probable cause and what is sufficient particularity are subject to the standard of reasonableness, which the Supreme Court has indicated is subject to different standards. That is, the standards under the Fourth Amendment for criminal warrants, for arrest warrants, may be different from those necessary for foreign intelligence collection and counterintelligence investigations. Just to clarify that NSA, the National Security Agency, is in the foreign intelligence business. They're concerned with the plans, capabilities, intentions of foreign governments. The FBI is concerned with counterintelligence work, with countering the efforts of hostile intelligence services and terrorists in the United States and abroad. The definitions in FISA include a definition of international terrorism, as well as definitions of clandestine intelligence activities and terrorist organizations. The critical thing about terrorist organizations is that they bear a remarkable similarity to foreign governments. They have large numbers of people, they operate clandestinely, they have training facilities, they have weapons and munitions, and today they use the worldwide network of sophisticated communications to further their terrorist plans. The intelligence issues, the intelligence activities at issue in the proposed bill from Senator Specter, that is, surveillance of terrorist communications networks, are directed at foreign powers and their agents. They include primarily collection abroad, but since the networks are undetermined when these surveillances begin, it is not unreasonable to expect that some of those communications may come to persons in the United States. Based on my personal experience, I would think that they are relatively small in number. However, they are extremely important because communications to the United States from terrorist networks abroad would signal a presence in the United States of terrorist cells, as well as a forthcoming attack on the United States. In the 1972 landmark decision of U.S. versus U.S. District Court, after striking down the executive branch's warrantless surveillance program, by the way, in that case, it was a bombing case in Ann Arbor, Michigan, of a CIA recruiting station. Nevertheless, the Supreme Court struck it down, but in doing so, the Supreme Court sent a signal to the Congress. The Supreme Court said that the Fourth Amendment was highly flexible and that the standard for criminal, what they call ordinary crimes, what I would call traditional law enforcement, need not be the same as that for foreign intelligence collection, and that different standards for different government purposes are compatible with the Fourth Amendment. That decision served as the basis for the FISA statute. There was actually a FISA statute from 1976 supported by Attorney General Levy and President Ford. That never passed. It was the Act of '78, championed by Attorney General Griffin Bell and President Carter, that actually passed when I came to be involved in these intelligence activities. The reason I got involved is I was originally hired in '75 to write the FBI's guidelines for domestic security and counterintelligence work. When that was done, some staff unit was necessary to apply the guidelines and then to handle the warrantless surveillances and then the FISA surveillances. And so I turned out to be the natural repository for that authority. Because of the differences between traditional law enforcement and the intelligence gathering requirements of the Fourth Amendment, the standards for intelligence gathering may be substantially different from those for traditional law enforcement. Notice I've used the words different, not lower. In other words, under Rule 41 of the Federal Rules of Criminal Procedure, if you want an arrest warrant, you must convince a judge there's probable cause to believe that somebody has committed a crime, and then you must particularly describe that person. If you want a search warrant, you need probable cause to believe that the place to be searched contains the contraband or illegal substances, and you must describe that place with particularity. Under the FISA statute, you need probable cause to believe that someone is a foreign power or an agent of a foreign power. You must also describe with some particularity what you want to seize. And in the case of FISA, what you want to seize is foreign intelligence information. One of the critical factors in this is that the information, which is often foreign intelligence, can often be considered criminal evidence. That has always been a complicating factor in the operation of the FISA statute. I think that for the purpose of Senator Specter's bill, the critical factor here is that in targeting terrorist communications networks abroad and applying the standard of reasonableness, you have to look at the fact that the terrorists are located outside the United States. They're overseas in foreign lands, using foreign languages, modern modes of communications to carry out their terrorism. Thus, it would be unreasonable to expect U.S. intelligence agencies to know in advance the identity or identities of all of the people in these intelligence networks, where they're located, what their telephone numbers are, what their email addresses are. Indeed, this is the very purpose of the FISA surveillance, is to identify these people and neutralize their terrorist activities. As I mentioned, U.S. persons may be in the network or chain of communications of known terrorists, but there will undoubtedly be many other people in the communications network who are unknown to the intelligence agencies. Some of them may include U.S. persons. Thus, it is perfectly logical and reasonable to expect that although the program is targeted against terrorist networks abroad, that communications may come to the United States and are of great intelligence interest. This situation is not unlike things I've seen as a magistrate judge in drug trafficking, where the DEA and state officers are able to secure a cell phone used by a drug dealer. They look at the records of the cell phone, they see he's talked to other cell phones, and the people on those cell phones have talked to other people on cell phones. And so the DEA begins to track all of the people to identify the people in the network of drug trafficking. But till you get the records from the communications companies that keep these phone records, until you determine what the pattern of operation is, until you determine the identities of these people, it can take more than a year. And that was a case I recently saw in Gainesville. However, we don't have that time in dealing with international terrorism. Thus, as phone communications or email communications are moving rapidly in international commerce, intelligence agencies need to follow those communications without coming back to the FISA court to specifically identify each individual in the network the way the law enforcement officers do in the drug trafficking networks. And that's where I ended up a few minutes ago. That is, the Fourth Amendment permits Congress to empower the President to seek judicial warrants targeting networks of communications of terrorists abroad without having specific probable cause for all of those in the network, including the incidental collection of U.S. person communications. And the critical factor here is the reasonableness standard in the Fourth Amendment. The Fourth Amendment is not a suicide pact. It is intended to be a check on government authority. And what is required is a reasonable application of that authority. And so when you're dealing with these communications networks worldwide, Saudi Arabia, Pakistan, Dubai, and all the countries in Southeast Asia, we cannot, that is, U.S. intelligence cannot know who all these people are and come to court, and each time someone is identified in the network, to rush back in the next morning and come to court. So the government, the intelligence community, needs a reasonable amount of time to gather this information and analyze it and determine who are the real terrorists and who are the people who are being contacted but not necessarily involved in terrorism. These collection programs would be primarily focused on networks outside the U.S., supported by probable cause. I believe your bill calls for identifying at least one person in the network, but not requiring the identification of all of the persons in the network. And we support that basic concept, because it would be unreasonable to expect the government to have that information and present it to the judges. But balanced against that broad collection is restrictive minimization procedures. And I don't think many people understand what minimization procedures are, and so I'm going to explain them. It's not a difficult concept. Most foreign intelligence information is collected in foreign languages. Much of it is encoded or encrypted or uses vague concepts. For example, terrorists might say, is everything ready for the wedding? Have all the presents for the wedding been gathered? When referring to terrorist activities. So the first step in minimization is that the information collected, whether in electronic surveillance or research, needs to be translated or decoded and put into an intelligible form. Once it's in an intelligible form, then the intelligence agencies can make an analysis. Is it foreign intelligence information? And if so, how does it fit into the big picture? And if it's not, then we shouldn't be keeping it. Thus, in discussing this with your staff, I suggested some changes to the bill, simple ones. For example, in Section 701, where it talks about program, it's often misleading, and some people, I think, have misunderstood the purpose of the bill to think that the bill would allow targeting of just generic programs as opposed to specific terrorist networks. So in the definition of your program, in Section 701(5), where it says the term electronic surveillance program means a program to engage in electronic surveillance, I would add targeting terrorist communications networks. That's what the program is about, targeting terrorist communications networks.
Judge Kornblum, how much more time do you think you'll require?
5 minutes.
Thank you.
I can stop now if you...
No, proceed. 5 minutes would be fine.
Based on I wrote the original sets of minimization procedures which have been in use by the FBI and NSA since 1978. They've been amended from time to time to deal with new problems. But what I would see is, under your statute, broad collection, including incidental collection of Americans, if that should come about, but with stringent minimization at the end of the surveillance period. That is, if the information is determined not to be foreign intelligence, it should be discarded. If it is foreign intelligence, it should be used to produce additional applications in the FISA court. But there's going to be a large body of information about which the intelligence community would not have had an opportunity to do a complete analysis and determine if it's foreign intelligence. In those cases, I would allow the government to come to the FISA court and seek a motion to allow the government to continue to retain the information for continued analysis until such time with continuing court approval. And I'll now just spend a few minutes talking about presidential authority. Again, I'm not talking about the president's program. Presidential authority to conduct wireless surveillance in the United States, I believe, exists, but it is not the president's job to determine what that authority is. It is the job of the judiciary. Just as the judiciary determines the extent of Congress's authority to legislate, so it determines the executive's authority to carry out his executive responsibilities. The president's intelligence authorities come from three brief elements in Article 2. The executive power is vested exclusively in the president, so is much of the responsibility as commander-in-chief, as well as his responsibility to conduct foreign affairs. All three are the underpinnings for the president's intelligence authorities. Most of the authority I see referred to in the press calls it inherent authority. I'm very wary of inherent authority. It sounds like King George. It sounds like the kind of authority that comes to a head of a nation through international law. As you know, in Article 1, Section 8, Congress has enumerated powers, as well as the power to legislate all enactments necessary and proper to their specific authorities. And I believe that's what the President has, similar authority to take executive action necessary and proper to carry out his enumerated responsibilities, of which today we're only talking about surveillance of Americans. Again, I emphasize that it's the judicial decisions that define the President's authority. These decisions predate the FISA statute, and I was reviewing the FBI and NSA applications for warrantless surveillance. Those surveillances, by law, were transferred to the FISA court in 1978, and actually when it began in May of '79. However, the FISA statute has very specific definitions, and there are intelligence activities that fall outside the FISA statute. Those activities went forward and have continued to this day and are still being done under the President's authority as set forth in the executive orders describing U.S. intelligence activities. There were 3 orders: President Ford's order, 11905, President Carter's order, 12036, and the current order, 12333, which was issued by President Reagan in December of '81. That order has been used by all of the presidents following President Reagan without change. And I was responsible for processing those applications. They go to the Attorney General based on a delegation of authority. I've asked the staff to give you a copy of the current executive order, and that's the authority that is being used today to some extent. The presidential authority that is being used today is being used unilaterally. I think all of the judges agree with me that when the President operates unilaterally, his power is at its lowest ebb, as has been mentioned in judicial decisions. But when Congress passes a law, such as one in authorizing the surveillance program targeting communications networks, when the Congress does that, and the Judiciary has a role in overseeing it, well, then the executive branch's authority is at its maximum. What that means is they can do things, I believe, under an amended FISA statute that they cannot do now. For example, the President's program says that the President reviews it every 45 days. But I would think if Congress authorized the program and the court oversaw it, that the surveillance programs could run for 90 days.
Judge Kornblum, would you summarize at this point?
I'll go back to what I started, that I think the judges all think that Congress can empower the President to conduct broad foreign intelligence surveillance programs targeting the communications networks of terrorists abroad, that the program can be monitored effectively by the FISA court, that security can be maintained, and the bottom line would be an enhanced foreign intelligence collection program.
Thank you very much, Judge Kornblum.
Mr. Chairman, could I just have 30 seconds? I just need to explain why I have to leave at this point, if I could. I would appreciate it, Mr. Chairman. I just want 30 seconds. Mr. Chairman,
go ahead.
If I could. I was on the bipartisan delegation that went to Iraq this weekend, and the President has asked that we come to the White House now to brief him on that. Obviously, I regard this hearing as extremely important, and I am keeping an open mind on the Chairman's legislative idea. I just want to comment after having listened to Judge Kornblum, and I will have to read the transcript with regard to others. I don't think anyone could reasonably take what the judge has said to suggest that there is legal authority for what the President is doing now.
If you want to explain your departure, we understand that. But we do want to proceed in an orderly way here, and everybody's waiting to have a turn to comment. Let us turn now to Judge Baker, who received his bachelor's degree from the University of Illinois, his law degree from the University of Illinois College of Law, appointed to the United States District Court for the Eastern District of Illinois in 1978, served as Chief Judge from 1984 to 1991, became senior status in 1994, and was appointed a judge on the U.S. Foreign Intelligence Surveillance Court in 1998 by Chief Justice Rehnquist. Judge Baker, thank you very much for the very thoughtful analysis which you have provided to the committee, and we look forward to your testimony.
Thank you, Mr. Chairman, and I want to express my, was it not on?
How's that? I'll start again. Thank you, Mr. Chairman, and I want to express my appreciation for the privilege of being asked to come here and speak to the committee. Like the other judges, I'm only speaking individually. I'm not expressing opinions on behalf of the FISA court or its members as they're presently constituted. And what I hope to comment on is in a constructive manner to strengthen Senator Specter's bill and the functions of the FISA court, to strengthen the FISA court. What Judge Kornblum said about the FISA court being an invaluable tool to the intelligence community bears emphasis. The FISA statute, I suppose I only tell you what you know, is the compromise that was worked out between the congressional right of oversight and the powers of the executive in gathering foreign intelligence. And it ends up being a balance between the constitutional construction and pragmatic necessities. It ended up that the intelligence community needed court orders in order to gain access to the carriers, the communications carriers. One of the problems that seems to arise, and I mentioned this to Senator Specter, is the lack of understanding. It's amazing to me on the part of the Justice Department and the intelligence community as to what probable cause has to be. They have some idea that probable cause is a high bar that they have to cross. And in foreign intelligence matters, it is not. And if they go read Illinois versus Gates and Maryland versus Pringle, where first Justice Rehnquist and finally in the Pringle case, Chief Justice Rehnquist elaborates further, it comes down to a very practical, common sense decision, which in the case of foreign intelligence boils down to just a reasonable suspicion. The other aspect in the statute that bears discussing is minimization, and that also, like the determination of probable cause, minimization should be a judicial decision, an oversight by the judiciary of what the executive's doing. I should call attention to the committee to the in re seal decision that was decided by the FISA Court of Review, which put two limitations on the FISA court that exist now. First, in determining probable cause, saying that except for clear error, the court should not look past the determination by the executive of the existence of probable cause to think the communications would contain foreign intelligence. And the other was that minimization is not or should not be solely a function for the executive, and that it is subject to review, that the minimization standards established by the Attorney General are reasonable and intended to protect Fourth Amendment rights of United States persons. The point I wanted to stress, and I did with Senator Specter in my letter to him, was that the Congress should tell what its intention is, specifically what its intention is with regard to who has the right to decide probable cause, who has the right of oversight of minimization. And I see the clock ticking away. I think I'm in an appellate court again. And I'd be delighted to answer questions that may be put to me by members of the committee. Thank you, sir.
Thank you very much, Judge Baker. Our next witness is Judge Stanley Brotman from the United States District Court of New Jersey, appointed there in 1975, bachelor's from Yale, law degree from Harvard, served in the Counterintelligence Corps and Office of Strategic Services in World War II, and in the Korean War in Armed Forces Security, a member of the FISA Court from 1997 until 2004. Thank you for coming to Washington today, Judge Brotman, and we look forward to your testimony.
Thank you, Senator. Good morning, everyone. Like the other judges, I also am honored to have been asked to appear before your committee this morning to discuss the draft legislation entitled the National Security Surveillance Act of 2006. As you mentioned, I served as a member of the United States Foreign Intelligence Surveillance Court from May 1997 to May 2004. And I might add that, coincidentally, when I was recalled to active duty for the Korea campaign, I was assigned to an organization known as the Armed Forces Security Agency, which is a predecessor of the National Security Agency. Only in those days it was operating solely from a military standpoint. I feel that since the other judges will be talking a little more of the legal intricacies, I would try and give you a picture of the FISA court as it really works. Who makes it work? Its composition, the type of judge who serves on the court, who appoints that person, and such other aspects of the operative procedure that I feel can be disclosed. And it's really to give you added confidence to those who do not know or have not heard very little about this court, what this court really is, and how it approaches the issues that come before it. Again, I also will say I'm talking only for myself, and I'm not speaking for the FISA court or any member of the FISA court. My remarks are intended, as I said, to give you a feel for this court. Starting with its inception in 1978, the process of appointment to the court was handled through the appointment of each judge by the Chief Justice of the Supreme Court of the United States. The term is a 7-year term. The judge cannot be reappointed. When his term is over, it's over. Prior to 9/11, the court was comprised of 7 members. Subsequent to 9/11, it was increased to its present membership of 11 members. There's a geographic mix, an ethnic mix. Each of these judges are United States District Court Article III judges who have had extensive trial experience and have had a very, very interesting dossier. Now, how are the matters presented to the court? What's the process? The process is by an application submitted by the requesting party's authority, passed through various stages of review within that particular authority by the Attorney General and others, and then it is filed with the court. In other words, if there are extensive reviews even before it reaches the court in terms of making sure it complied with the provision of the statute and the facts of the situation. It is then thoroughly reviewed by the assigned judge, and the agent or representative of the applicant appears before the judge at a hearing that is held, and if there are no problems, an order is issued allowing the collection. If there are problems, the judge will raise them and send the application back for further review and presentation. The culture of the theory of the court is we're not there to stop the collection of information. It's vital to the security of the United States. What we are there is to help those who make the application by making sure they comply with the law, with the statute, and as I say, if they're not complying or something is lacking, we'll send it back and you resubmit it. And that discipline has grown up over the last 28 years. As I said, the application must meet the request of the statute and of the Congress in the legislation creating the court. And there must be, as we review these applications, there must be a balance between the needs of the surveillance and the protection of the provisions of Article 4. This balance has already been discussed by both Alan and Harold, and I'll not repeat it, but it is crucial. And that balance is not always the same. It depends on the application of what is being sought. The judges assigned to this court, and I think I can say this about all of them, they really have dedicated themselves to doing the job that they're there for. They recognize the security of our country is at stake. They recognize the protections due our citizens. They're hardworking. At times, I was visited at my home in South Jersey 2 or 3 o'clock in the morning to sign orders. I was even found out in California where I was attending a meeting at one time. FISA has worked and worked well. It is a necessary court, and its orders reflect the balance to which I have made reference. It has no axe to grind, this court. Judicial review provides confidence to the citizens of our country to know that a court has looked on what is being sought. Times change, methodology changes, equipment changes, processes change. All these things can be and should be accommodated with the FISA court. And again, I say I support, as do the other judges, the proposed amendment by Senator Specter in his draft. I thank you very much.
Thank you very much, Judge Brotman.
Sorry I went over 1:46, but...
You are welcome to the extra time and beyond, Judge Brotman. We appreciate your coming in. We're not running stopwatches on the court. On some other witnesses, maybe yes, but not on the court. Turn now to Judge John F. Keenan from the United States District Court from the Southern District of New York, appointed in 1983. Judge Keenan is a graduate of Manhattan College, Fordham Law School, was in the Army from 1954 to 1956, an assistant district attorney in New York County to the famed prosecutor D.A. Hogan, whom I worked with in the so-called good old days, Deputy State Attorney General and Special Prosecutor for Corruption in the City of New York from 1976 to 1979, appointed to the Foreign Intelligence Surveillance Court in 1994 and served there until the year 2001. And he's on senior status now. Thank you very much for joining us, Judge Keenan, and we look forward to your testimony.
As the other judges have said, it is an honor for me to have been asked by Senator Specter to appear before your committee and testify concerning Senator Specter's proposed draft bill entitled the National Security Surveillance Act of 2006. As you heard, I served as a member of the United States Foreign Intelligence Surveillance Court from May of 1994 until May of 2001. While I was in the Army, I served in the Far East in military intelligence in the Army Security Agency, which, as Judge Brofman said, was the precursor to the National Security Agency. During my tenure on the FISA court, the court consisted of 7 district judges, no 2 of whom could be from the same circuit. We each served for 7-year terms that were staggered terms, in the sense that one new judge would come on each year and one judge would go off. And those 7-year terms could not be extended. I know that Title 50, Sections 1801 and those sections that follow, the Foreign Intelligence Surveillance Act, or FISA, was amended after September 11th, and that the court now consists of 11 district judges. FISA was originally enacted in 1978, and it is what I will call a Fourth Amendment statute. This is because in order to secure a FISA warrant, the Attorney General must establish probable cause. However, FISA probable cause is different than probable cause in the criminal context. In a FISA application, all the government must show is that there is probable cause to believe that the target is a foreign power or the agent of a foreign power. In the case of a FISA warrant, the seizure is of foreign intelligence information. At present, as we have all heard here this morning, this whole area is one where there is considerable controversy and disagreement. It is not my purpose, nor do I think it appropriate, for me to allude to the politics of the subject. I respectfully suggest to you that FISA has been a valuable tool for the nation in the collection of foreign intelligence. FISA can be improved, and it should be improved to accommodate more modern technology, which was not contemplated in 1978 when the original law was enacted. I believe your legislation, Senator Specter, with certain modifications, would improve FISA very much. Contrary, I should say, to an editorial that appeared in the February 9, 2006 Wall Street Journal, FISA and the Foreign Intelligence Surveillance Court should not be abolished. Under Article 2, Section 2 of the Constitution, the executive has great power and authority in this area, as you've already heard, and as you know. So too does the legislature under Article 1, Section 8, as is recognized in your bill and as is set forth in your bill. Whatever legislation is enacted should accord these two principles sufficient and significant recognition. It is my understanding that the legislation before you proposes to supplement the present law, not to overrule, repeal, or supplant it. I am aware that Section 1805F of FISA was amended to authorize the Attorney General to employ electronic surveillance to obtain foreign intelligence without a court order for 72 hours in emergency situations. It is my understanding, based on an article in the March 9th New York Times, that there is a bill in the Senate Foreign Intelligence Committee seeking to allow warrants without court orders for up to 45 days. The National Security Surveillance Act of 2006, which is before you, makes no reference to the 72-hour period and thus presumably leaves it in place. I would respectfully suggest that the period be increased to 7 days or 168 hours in emergency cases. This should be more than ample time to address any unforeseen emergencies if FISA was amended and extended to 168 hours. The legislation before you presumably leaves in place Section 1803B, which establishes a three-judge court of review over the FISA court. In 2002, the review court sat for the first time and ruled at 310 Federal Reporter 3rd, page 717, that, quote, FISA does not contemplate, close quote, an en banc proceeding wherein all the judges sit contemporaneously. The legislation here makes no reference to en banc proceedings, and if there is a desire on the part of your committee, and it seems to me that in certain cases it might well be valuable to be able to have en banc proceedings, and since they are now outlawed, that might be a helpful addition to the legislation. The legislation before you in proposed Section 701 defines several terms. Among them is the term, quote, electronic surveillance, close quote. I respectfully point out that this term is already defined in present Section 1801F, and that there are differences in the definitions which probably should be harmonized in the new legislation. Because of modern technology, United States persons may well be in the network or the chain of communication of known terrorists. Concerning those terrorists, there may well be ample probable cause, but little or nothing may be known other than that he is receiving communications from the terrorists. I believe in the context of intelligence gathering that the Fourth Amendment allows Congress to empower the President to seek warrants targeting networks of communication used by people, including United States persons, where the network is engaged in terrorism or activities related thereto, without having specific probable cause for all people in the network. I believe that your legislation, sir, accomplishes this important purpose and takes into account the sophisticated modern technology employed in present-day electronic communications, while recognizing the need for minimization procedures. Thank you very much.
Thank you very much, Judge Keenan. Our final witness on this panel is Judge William Stafford from the United States District Court for the Northern District of Florida. Judge Stafford is a transplanted Pennsylvanian, Mercer County, and wife from Franklin County. I was pleased to learn this morning. Graduated from Temple University in 1953, bachelor's degree and a law degree from Temple in 1956. Served as a Navy lieutenant for 4 years. Was a state attorney for the First Judicial Circuit of Florida, the equivalent of a district attorney, and served as United States attorney from 1969 to 1975 for the Northern District of Florida when he was appointed to the district court. In 1996, he took senior status, was appointed to the Foreign Intelligence Surveillance Court, where he served until the year 2003. We welcome you here, Judge Stafford, and the floor is yours.
Mr. Chairman and members of the committee, you have done me the honor of soliciting my comments on the draft legislation entitled the National Security Surveillance Act of 2006. It is my judgment that these proposed amendments to the FISA statute strike a reasonable balance between the President's power to conduct foreign affairs, including electronic surveillance, and the Congress's power of oversight over the same. By positing the power to review and/or authorize this surveillance in the FISA court of the third branch, this legislation accommodates the power of the President to fulfill his duty to protect the nation against terrorism from without, while the civil liberties of Americans are being watched over by judges whose lifetime appointments put them above the current political clamor. For those of us who came of age during the Cold War, the world political scene and the communications universe have changed dramatically. It is well then that the FISA statute, created nearly 30 years ago, be looked at and revised in the light of the world as it really is in the year 2006. When FISA was first enacted in 1978, the Congress codified the President's power to conduct foreign intelligence surveillance and the method by which that could be done. In 1984, Congress amended the FISA statute to permit physical searches under the same foreign intelligence surveillance umbrella. The Berlin Wall has since come down and other artificial borders have disappeared, while wireless computers, cellular telephones, and other electronic creations have reduced the communications distances to nanoseconds. The events of September 11, 2001 and their aftermath demonstrate that while it is indeed a different world in which we now live, constitutional principles still apply, and your proposed legislation accommodates both of these verities. Your amendments create an electronic surveillance program in which the Congress recognizes that it is, quote, not feasible to name every person or address every location, and requires, again quoting, an extended period of electronic surveillance. This is another recognition not only of the change in the world scene and in communications abilities, but also of the difference between traditional criminal prosecution and foreign intelligence gathering. By requiring a justification for continuing the surveillance, and by establishing enhanced minimization procedures, these amendments offer a reasonable approach to meeting both the need for national security and for protecting Americans' civil liberties. Foreign intelligence surveillance, has been mentioned, is a different form of executive function than is law enforcement, and your proposed legislation recognizes that. In my considered opinion, it is well that a different threshold is set for the initiation and/or the continuation of foreign intelligence surveillance, as contrasted to the traditional Fourth Amendment probable cause that is required in criminal search and seizure warrant applications. This is because the purposes of the intrusion and collection of information in each case is different. In the typical Fourth Amendment search and seizure context, the individual and/or the place and/or the type of evidence are generally spelled out in the warrant application, and criminal prosecution is the end game. Under FISA, the governmental function is the gathering of foreign intelligence information. And while the intelligence gatherers are not required to turn a blind eye to violations of the criminal laws, prosecution is not the purpose for the initiation or continuation of the foreign intelligence surveillance. Spelling out in your legislation a different level for the initiation and or continuation of foreign intelligence surveillance has the additional benefit, Mr. Chairman, of providing guidance for those courts that may be called upon to review the product of any such foreign intelligence surveillance. Should evidence, incidentally, gathered as a result of a FISA warrant be offered in a criminal case, and there be challenged as a product of an unreasonable search and seizure, it would be comforting for the trial judge and for the Court of Appeals judges who may have the same issue on appeal to know that Congress made the deliberate choice to set a different threshold for foreign intelligence purposes. Illinois against Gates has been mentioned. As my recollection, that arose in a criminal case context. And while the language of that opinion may well allow for different levels of consideration depending upon the purpose for the warrant application, having the legislative intent clearly stated here removes any doubt as to what the Congress would authorize or sanction in the FISA context. Choice of language to accomplish this is for you as drafters, but I respectfully suggest that if it is the will of Congress to set a different standard for foreign intelligence surveillance gathering, that you do so for the benefit of the other two branches of government and for the American people. As I approach my 75th birthday, it remains my belief that our nation is really held together by a couple of pieces of paper, the Declaration of Independence and the Constitution, and the belief of the American people that our system of government works. FISA was created by Congress to clarify that the President had the authority to conduct foreign intelligence surveillance, but that the President would do so through a court composed of judges who had been nominated for lifetime appointments by a President and confirmed by the Senate as provided in Article 3 of the Constitution. This arrangement seems to have worked well for everyone, and these amendments will, in my judgment, continue that arrangement into the real world of the 21st century. Thank you, sir.
Thank you very much, Judge Stafford. Very profound. The two pieces of paper, so long as we follow them, and with a great tradition for balance of power and for separation of power, which we're going to the heart of today. We'll now begin the 5-minute rounds of questioning by members of the Senate. And I will begin, Judge Baker, asking you about your testimony on minimization and establishing probable cause. And you are testifying that you think that the Foreign Intelligence Surveillance Court would be in a position to analyze the administration's program, whatever it turns out to be, to see to it that those two constitutional requirements are followed if my bill was enacted, correct?
Yes. I would urge you not to abandon the language of the Fourth Amendment of probable cause. Probable cause is the test, but there's a different probable cause that applies in a foreign intelligence case. And going back to how I feel the effectiveness of FISA court was limited by the INRI sealed case decision, saying that we shouldn't look behind the minimization procedures. We had no right of review. I think that is an oversight function that the Congress intended, and also that we shouldn't look behind the determination of probable cause. Probable cause has always been a judicial determination when it comes to a warrant.
And that can be accomplished with the legislation which I've proposed.
Absolutely. Yes, sir.
Judge Stafford, you testified about the necessity for balance and cited the advances in electronics and wireless, and you're looking for a balance for national security and protecting civil liberties. And do you think that the legislation which I have proposed will take into account the modern technological advances and, with the FISA court review, provide that kind of balance?
Yes, sir. I do. I think you recognize that, as I indicated, that it's not possible to name everyone, and therefore, and as previously noted, the electronics just flies around this world so quickly, and the prospect of running to the court every time, it seems to me, is not possible. So I think your legislation is broad enough to permit the gathering of the foreign intelligence information and the minimization procedures to strike from that anyone who's, particularly U.S. persons, who may not have any foreign intelligence purpose whatsoever. So their names could be eliminated. So I think the legislation will accomplish that, Senator.
Judge Keenan, you've sounded a similar note talking about technology and the Foreign Intelligence Surveillance Act, as you testified, should accommodate those changes which we find today, contrasted with 1978 when FISA was enacted. Do you think that the legislation which I have proposed will appropriately take into account those changes in technology and provide the kind of judicial review which would establish constitutionality and at the same time give appropriate balance to law enforcement?
Yes, I do.
You?
Yeah. I'm sorry.
Oh, that's fine. We'll get a double answer.
I agree with Judge Brotman.
Wait, well, let's
No, I certainly
but
do
before you
think-
answer, I want to be sure we have Judge Brotman on the record. I thought I heard you say, yes, I do.
Yes. I was going to
Okay.
say something else, but I'll let him answer first.
Okay.
I certainly do agree that the legislation serves the purpose that you suggest. And if I may, most respectfully, I'd like to repeat my suggestion that the 72-hour provision be extended to 168 hours, in other words, 72 days, from 72 hours to 7 days, I'm sorry. The point being that emergencies sometimes arise. You heard from Judge Kornblum, I think, the number of steps and hurdles, in a sense, that the FISA application has to go through before it ever gets to the court. And you heard it from Judge Brotman to a judge of the court. Emergencies do arise in life, and particularly with the type of communications we're talking about, which were never envisioned in 1978. When you were district attorney of Philadelphia and there was a wiretap, or when Senator Kennedy was an assistant up in Massachusetts and there was a wiretap, there were two people on the wire. That's not the way it is now, and that's what has to be covered, and you're covering it.
Thank you, Judge Keenan. Judge Brotman, the red light went on, and I like to observe the red light so that everybody else does. Chairman has to be the leader on that. We'll come back to you on my next round. Yield now.
Go ahead if you want.
No.
We're taking from my time.
Want to observe the time. Senator Leahy.
Judge Keenan, you bring back some memories for a number of us on this panel were prosecutors. I won't go into telling war stories. I do have a question. It's been reported that the current presiding judge of the FISA court, Judge Catelli, and her predecessor, Judge Lamberth, expressed doubts about the legality of the president's warrantless wiretapping program. Both insisted that information obtained through NSA surveillance not be used to gain warrants from the FISA court. Do you agree with the decision of the presiding judges to bar the Justice Department from using information obtained from this program in their FISA applications, Judge Baker?
I'm not familiar with her decision on that, and I'd like you to excuse me from interfering in the proceedings of the existing court. I don't know, see what's been presented to them. I'm really in the dark of that, and for me to give an answer on it would be speculation.
Judge Brotman, do you have any different answer?
No, I'd give the same answer.
Keenan?
I'm afraid, Senator, I would give the same answer. I don't know what the program is, and I have never been briefed.
I agree with my colleagues, Senator Leahy.
Okay, well, let me ask you this then. Suppose the Justice Department wanted to test the legality of the NSA program. And let's assume for the moment that the facts are as I described them by the chief judges. If they want to test the legality, couldn't they do that any time by applying for a FISA warrant based expressly on evidence obtained through the program? That is, evidence obtained through a warrantless wiretap of an American inside the United States. If you have a case where evidence is obtained through a warrantless wiretap of an American inside the United States, Justice Department now comes forward and asks for a FISA warrant based on that. On those facts, would that not put the judge in a position to consider whether the evidence obtained lawfully?
The judge would
Take it as a
consider,
hypothetical.
well, the judge would have to consider whether there was probable cause to believe that a foreign power was involved and that the communication was between a foreign power and there's probable cause to believe that the recipient is an agent. That would fall within the statute if that was present. But I don't know that would be present.
And that would be, in doing that, would be making really the determination whether it was lawfully obtained. And asking the questions you've just referred to.
Because it goes beyond the question of a foreign power and the agent of the foreign power, and is raising the question of whether the president has the authority to do such a thing.
Mm-hmm.
And again, I end up saying I can't answer it because it would amount to speculation.
You can't answer a question whether if the Justice Department came in applying for a FISA warrant based expressly on evidence obtained through a warrantless wiretap of an American inside the United States, you couldn't ask a question whether the evidence was obtained lawfully under FISA? That doesn't seem to make a lot of sense. I mean, put another way, suppose they came in a court came in for a warrant to search a safe deposit box. And they said, we're developing our probable cause based on an earlier warrantless search of the suspect's home. Wouldn't, before you issued that search warrant for the safe deposit box, wouldn't you have to at least reach a question of the legality of the search of the home?
I might come to the conclusion that there was insufficient information because the information wasn't reliable to find probable cause. But I don't know that I have to go back and decide with what the executive doing is legal or illegal.
Well, then let me final with this. Mr. Halpern is going to testify in the next panel. He said, should Congress seek to legislate based on the record currently before it, such legislation should respond to the specific needs that have been asserted by the government rather than to conjectures as to what additional needs may exist. Do you disagree with that? I mean, you're saying you wanted to have the facts. And Mr. Halpern saying the same thing?
I guess, you know, I came to talk about the proposed legislation and how it would assist and reinforce the FISA court, and what the existing situation is now with whether something's legal or illegal goes beyond that, and that's why I'm shying away from answering that.
With the head shaking, I have a feeling I would get the same answer from Judge Brotman, Judge Keenan, and Judge Stafford.
I would say this, Senator, that any application made to the FISA court would have to be considered by the judge who receives that application. And in the course of reviewing that application, if it doesn't meet with the statute, then the application is not granted. We have to use the information in the application and the information we've learned. And all of us become briefed on new programs. We become briefed on new equipment. We see how things operate. We have to in order to do our job. But if an application comes in and doesn't meet what it should meet, it goes back.
Judge Kornblum reminds me, Senator Leahy, that in the Ames case, that warrantless searches were disclosed to the court, and the court did proceed on the basis of those warrantless searches
And then we
further
amend,
FISA surveillance.
and
Sir.
then we amend FISA after that to, at the request of the administration, to take care of cases like Ames?
Yes, it was amended.
Thank you, Senator Leahy. Senator Hatch?
Well, I want to personally thank all of you for your service to our country, and we appreciate what you folks in the federal judiciary are doing for all of us. We thank you for being here today and appreciate all the testimony we've had. I'm going to direct my questions to you, Judge Kornblum, if I can, and anybody else who would care to respond would be fine with me. When the accusation authorization of the NSA terrorist surveillance program are put together, the picture looks something like this. The President is given a mandate from the Constitution as Commander-in-Chief. The Congress, in response to domestic spying by certain administrations in the 1960s, devised a legal avenue by which the administration can conduct surveillance on Americans, and thus the FISA court was born. Therefore goes the argument, if the administration is to engage in any kind of surveillance, it must go through the FISA court. One senator described FISA like a trap with two escape hatches. Another senator says the FISA court is not a tool but the prescribed avenue which Congress has given for conducting surveillance. Now, if this line of reasoning is true, then the authority of the President has truly been diminished through the creation of FISA, the very thing FISA was not supposed to do. On top of that, the leak of this classified program has been hailed as, quote, a good thing, unquote, by some senators. Other senators have said publicly that they would be willing to give the President the explicit authority to conduct this program if the President had just asked. Now, I submit that when we sought to give law enforcement officers authority to use time-tested tools from years of investigating health care fraud or mail fraud, just to mention a couple of matters, under the Patriot Act, use those same tools in terrorism investigations, the same senators supported a filibuster of the Patriot Act. Now, this is not an administration spying on political enemies. This is a well-regulated, carefully targeted effort to stop terrorists. The administration discussed this program with several congressional members, and apparently none of them raised issues that so many are now trying to make political hay of today. And to my knowledge, no member has publicly requested the administration to stop the program, or even they haven't even suggested that funding for NSA should be curtailed. Now, Senator Specter has this bill, which is a good effort in my view, that addresses the issue of the FISA court and the power of the President to conduct surveillance on suspected terrorists. One of the criticisms circulating regarding this bill is the constitutionality of the proposed bill, and we're all concerned about that. So my question to you, Judge, and any of the other judges who care to comment, is this. If the administration files a request with the FISA court for permission to conduct something like the current terrorist surveillance program, and the request is denied, and subsequent revised requests are denied, does the administration still have the options to pursue in the effort to foil the terrorists, or should the FISA court's decision be a constitutionally infirm advisory opinion?
Well, you've overlooked the easy answer for me.
Sure.
There is a court of review. And just as back in 2001, when the administration objected to the court's decision in re all foreign intelligence matters, they appealed to the court of review. And that's the purpose, specific purpose for the court of review, so they would have a legitimate legal outlet to pursue.
Except this may be a crucial time constraining situation where lives of Americans, maybe millions of lives of Americans, may be at stake. So, again, would it be an advisory opinion in your opinion, or would it not be?
No.
Assuming that that situation is the situation, and I can tell you personally that very well may be the situation.
If the facts were presented in the form prescribed in the FISA statute and contained specific information regarding the foreign power, the agent of a foreign power, and explained how the surveillance was going to be conducted and met all the requirements of the FISA statute, I wouldn't think it's an advisory opinion. It would be a case of controversy for them to decide.
Even if it meant, even if it involved very, very serious potential harm to millions of Americans.
Yes, I'm not sure I understand your question, because it seemed to me almost all the FISAs.
Well, let's say that that we have some evidence that there is a widespread conspiracy to bring a nuclear device into America.
Right.
And that the FISA court decides that they haven't met the requisites a couple of times. Is the president bound not to do anything? Or is his only limitation to appeal the FISA court's decision to a court of review that might take a tremendous amount of time and might result in the loss of millions of lives?
Well, of course, the president would be relying on the Attorney General and now the new National Director of Foreign Intelligence for their recommendations. And I certainly don't consider myself an expert on presidential authority, but I could see the president deciding that using what I called his necessary and proper authority, he would assume the risk and order the executive action necessary, such as electronic surveillance, despite the court's approval or disapproval. And I gather that's the premise you wanted me to address. The court would disapprove the application, and there would be insufficient time to call in the court of review. What should the president do? Well, just as the president is now acting unilaterally, he might choose to do that. And
he might be right.
He might be right, yes.
Okay.
Thank you, Senator Hatch. We'll pursue that question of whether he might be right when my turn comes. Senator Feinstein was here under the early bird rule.
Thank you very much, Mr. Chairman. I think 4 of us on this committee are also members of intelligence, and 2 of us are part of the subcommittee that has been briefed on the program and has been out to the NSA and seen it. It was very interesting. What you said this morning was of great help to me. 2 of you have said that the probable standard cause is not a bar, but it's really lower than a Title III probable cause. It's really reasonable suspicion. Do all of you agree with that? Is anybody not agree with that? That for the collection of intelligence, the probable cause standard is really reasonable suspicion?
Sure.
I'm just not comfortable with those words. The reason that I say that is the cases all talk about, quote, probable cause. As I think we all tried to articulate, in my view, FISA probable cause is different than criminal probable cause. All you need with FISA is to prove, or not prove, but to establish probable cause.
I'm sorry, I can't hear you.
I'm sorry, excuse me. All you have to do with FISA, Senator, is establish that the target is an agent of a foreign power or a foreign power, and that the purpose of it is to gain foreign intelligence. Once you've done that, you've cleared the probable cause hurdle for the FISA Act.
Well, let me...
And if you want to call
right,
that...
let me... There are a couple of other things here that were very useful. I think the extension of the 72 hours to 7 days is very helpful. I think reviewing a program en banc is very helpful. There are a lot of contrasts that we have to deal with, and not the least of which is if you take something off a satellite, it's legal. If you take it off a wire, it isn't without a warrant. And as you have adequately pointed out, the technology has changed so much that a law passed in 1978 really needs to be changed for a program as opposed to an individual warrant. I think there is justification for a program. The question now comes on what should the probable cause or reasonable suspicion standard be exercised. It certainly seems to me that a FISA court sitting en banc is one appropriate standard. The other one comes down to probable cause or reasonable suspicion of what? Now, you have said agent of a foreign power or a foreign power, but it's also threat. It's also affiliation. I don't know that you would have the instant probable cause in a program if it's just limited to an agent of a foreign power or a foreign power, because you are trying to develop connections and you are trying to evaluate threat as well. Could you comment on that?
I think that all you have to do is look at Pringle, the most recent Supreme Court case, where they hark all the way back to Chief Justice Marshall and say a seizure under circumstances which warrant suspicion, and being the agent of the foreign power would be involved in these activities that you describe. So it seems perfectly clear to me that probable cause in such a situation is a very low bar, a very low hurdle to get over to make a warranted surveillance.
Of one, in other words, the foreign power is outside the country. The target is in the country. You'd also want to know, it seemed to me, who that target called.
Precisely. No, you would go after that target too.
Right. And so there, you're still agent of a foreign power, rather than a threat or a conspiracy?
The agent of the foreign power engaged in clandestine activities which are a threat to the United States. I mean, it's what that agent's doing that you'll be looking at.
All right.
Or we suspect that he's doing, or she.
Thank you very much. Now, I want to clear something up. Judge Kornblum spoke about Congress's power to pass laws to allow the president to carry out domestic electronic surveillance, and we know that FISA is the exclusive means of so doing. Is such a law that provides both the authority and the rules for carrying out that authority, are those rules then binding on the president?
No president has ever agreed to that. When the FISA statute was passed in 1978, it was not perfect harmony. The intelligence agencies were very reluctant to get involved in going to court. that reluctance changed over a short period of time, 2 or 3 years, when they realized they could do so much more than they'd ever done before without court
What do
orders.
you think as a judge?
I think, as a magistrate judge, not a district judge, that a president would be remiss in exercising his constitutional authority to say that I've surrendered all of my power to a statute. And frankly, I doubt that Congress, in a statute, can take away the president's authority, not his inherent authority, but his necessary and I forget the statute, the constitutional, necessary and proper authority.
Okay, I'd like to go down the
Yes.
line, if I could, Judge, please.
Well, I'm going
Judge
to
Baker?
pass to my colleague, since I answered before. I don't believe a president would surrender his power either. I don't believe that a president would surrender his power.
So you don't believe a president would be bound by the rules and regulations of a statute? Is that what you're saying?
No, I don't believe that. The president.
That's my question.
But no, I thought you were talking about the decision.
No,
that-
I'm talking about FISA. And is a president bound by the rules and regulations of FISA?
If it's held constitutional and it's passed, I suppose he is like everyone else. He's under the law, too.
Judge?
I would feel the same thing. I would feel the same way.
Judge Keenan?
Certainly, the president is subject to the law, but by the same token, in emergency situations, as happened in the spring of 1861, if you remember, and we all do, President Lincoln suspended the writ of habeas corpus and got in a big argument with Chief Justice Taney, but the writ was suspended. And some of you probably have read the book late Chief Justice Rehnquist wrote, All the Laws But One, because in his inaugural speech, not his inaugural speech, but his speech on July 4th, 1861, President Lincoln said, essentially, should we follow all the laws and have them all broken because of one?
Judge?
Senator, everyone, including the president, are bound by the laws that Congress passes, but everyone is bound by the law, but I don't believe, with all due respect, that even an act of Congress which can limit the president's power under the necessary and proper clause under the Constitution. And it's hard for me to go further on the question that you posed, but I would think that the president's power is defined in the Constitution, and while he's bound to obey the law, I don't believe that the law can change that.
So then you all believe that FISA is essentially advisory when it comes to the president?
No.
But that's what you're saying. My time is up, but this is an important point.
It was 4.5 minutes.
President isn't bound by it.
It was 4.5 minutes ago. But pursue the line to finish this question, Senator Feinstein.
I don't understand how a president cannot be bound by a law.
I could amend my answer
But
saying
if
that.
he is, then the law is advisory, it seems to me.
No, if there's
If he's
enactment, statutory enactment, and it's constitutional enactment, the president ignores it at the president's peril.
Okay. Thank you, Mr. Chair.
Let me interpose for just a moment here. I think the thrust of what you're saying is the president is bound by a statute like everyone else unless it impinges on his constitutional authority. And a statute cannot take away the president's constitutional authority. Isn't that, anybody disagree with that?
No.
Everybody agrees with that. And the question whether he has constitutional authority depends upon what he is doing. And that's why you have judicial review and have to know what the program is to make an evaluation, as the courts have done consistently with the president's authority. Once you know what a program is. And that's the thrust of what you have testified to in chief, when you've given your 5-minute opening in response to my questions, that the FISA court would have the authority to evaluate the specifics of the program and determine whether it is within the President's constitutional authority. Anybody disagree with that?
Senator, I would also reiterate that the President doesn't have a carte blanche, that the courts are the arm of government that determines what the President's constitutional authority is. And over these past 25 years, in addition to the FISA statute, the President has continued to exercise his constitutional authority to authorize intelligence activities.
I'll come back to this when my turn comes, but in light of Senator Feinstein's questions, I just thought that little bit of clarification might be in order. Senator Kennedy?
Thank you very much, Mr. Chairman. Thank all of you. This has been enormously helpful, and I think all Americans ought to have a sense of confidence in those that are serving on the FISA court. I certainly have been impressed by all of your presentations here and reassured. Just to go back very briefly, at the time that we passed that act, we had President Ford, Attorney General Levy. He brought the members of this committee down to the Justice Department. We worked out in a common and bipartisan way. The FISA Act was passed 95-1 in 1978. Many of us believe that it was enormously important, and I think history will show it. Now many of us wonder why we're not having a similar kind of a situation, why we can't, with the new kinds of challenges that we're facing here in the country with 9/11, why we cannot work in a common bipartisan way. We did at that time. We had the threats in the Soviet Union. There were provisions that were put in there as a result of secret information, all of which worked out and worked out very well. Now we have situations where we're having electronic surveillance on a number of individuals. Let me come before that. This hearing initially, well, first of all, has the comments on the chairman's proposals, have we all got the copies from your proposals? Has that been made available to all of us, Mr. Chairman? Do you know their comments that on your proposals have been, we all have those comments?
I will make a part of the record Judge Baker's comments, which are in writing, but those are the only comments which have, I will put on the record whatever
we
written comments have been made.
I thank you. Secondly, this was originally going to be a hearing that was going to be a secret hearing. Well, my question is, are we missing anything here that you would have told us? I mean, that's obviously, you can say yes, a lot, and then everybody's going to want to know what it is. And then my next question, what is it? And we can't hear it. But I'm just wondering, and I don't want to use up a lot of time on this, but are we getting the central thrust? Are we missing out on something here that we ought to sort of know about? Just very quickly, because I've got a short time. Please, Judge Keenan? Or?
I don't know anything more than what I had to say. I've been off the court since May of 2001, okay. So I don't know anything about the present situation other than what I've read in the paper.
So I just note that heads are going up and down, that we're really not missing out on a great deal. Let me ask you if you have concerns about the potential impact on criminal prosecutions when evidence is obtained from surveillance programs not approved by the FISA court. Judge Baker.
I certainly, when you get to the district court, I think that the prosecutor would have a real problem in trying to put forward evidence that hadn't been obtained with the judicial imprimatur first. I would be very worried about that.
Well, I think
in the in-re sealed case, it really went up originally because the Attorney General took the position you could use FISA for law enforcement purposes, and I'm the guy who has the singular notoriety of being the only FISA judge in history who's ever been reversed, because I signed that order, and it went up, and you know, we never said that you couldn't down the line use it, or you couldn't initiate and control it by the criminal division. I would be very concerned when I got to the district court if I was a prosecutor with that kind of evidence.
But the rest, Judge Keenan, Judge Stafford, have similar concerns.
I agree with you.
So here we have a situation under the current Justice Department. I think most of us have at least drawn the conclusion that some of these leaks on the NSA is because people are wondering about its constitutionality. We're going to find out in these courts whether the individuals, if they eventually get the al-Qaeda and they're holding them, generally thinking if you have a case that's just absolutely a closed case, that you might be able to get more information out of it. It enhances the government's ability to get more information out of those individuals, whether they think they might get off, and beat the rap on this. And what I think I'm hearing from you is that there is at least some concern about the question about the evidence that's obtained. Let me ask you this: what about the information? Is the government required to get a court order or some other written certification before the government can listen to telephone calls or read through emails? What's your understanding of the current law, the requirements you think that must be met before the federal can obtain information from telephone companies? The current.
What kind of, for instance, we issue orders for...
do they have to get some written kind of authority to turn these matters over under your understanding under the FISA?
That's the way it's been happening, absolutely.
And would you think that they'd have to do it if they're doing some other kind of process or some other procedure, the likes which has not been described in detail to us, but would you assume that they have to have the same kind of an...
I can only look back in history when the carriers refused to cooperate until they had a court order.
Others would believe that to be so as well. Just a final point. There's a point has been made about FISA being a rubber stamp. I think to the contrary. If you could outline just quickly, because my time is up, about the kinds of negotiations that have taken place. I understand there have been re-reviews of some of the requests, I think 93 or 4 different instances where you've perfected these kinds of requests. Just a last point. In response to the earlier kinds of questions with Senator Feinstein, we provide, if the President had a real issue on an emergency, we have in the FISA, have the 72 hours in any event. So if they didn't get the court, the President could move ahead in the 72 hours, I imagine. And as we remember, when President Carter signed that, he effectively said he was going to be bound by the law. President Jimmy Carter said we were going to be bound. That was in his statement at the time. But would you just, I'm exceeding my time, come back, any of the panel, talk just about these modifications? How do you, can you describe about that process? What can you tell us about, or how you've altered or changed? Is it something that is done sometimes, infrequently, frequently? What can you tell us about it?
In supervising the submission of the applications to the court, from time to time, members of the court would express concern regarding certain aspects of an application, such as conflicting information in the probable cause or greater specificity on the means for the surveillance. And we simply ask the court for an opportunity to conduct further investigation or gather additional information and file an amended application. And virtually every time that request was granted by the court, and amended applications were filed and approved.
So it's more than a rubber stamp. This is the point I'm trying to...
Oh, yes.
Oh, yes. Thank you. Thank you, Mr. Chair.
Senator Durbin.
Thank you very much, Mr. Chairman. Thanks to all the panel, and especially my friend Judge Harold Baker. I'm glad you're with us today. I'm trying to follow the statement made by my colleague, Senator Hatch, in describing the FISA law. And he said at one point that it wasn't the intention to diminish the power of the President. FISA was not supposed to do that. But I can't read that law without concluding that's exactly what Congress set out to do. By a vote of 95-1, they said that this was the exclusive means by which electronic surveillance and the interception of domestic wire, oral, and electronic communications may be conducted. Now, there's been a larger question raised by the chairman and by the members of the panel as to whether the President has constitutional authority which supersedes any statute. It seems to me at this moment in time that the President, with his new wiretap program, had 3 options. he could follow the FISA law, he could ignore or violate the FISA law, or he could seek to change the law. We know for certain he didn't take option number 1 or number 3. He didn't follow the FISA law, nor did he seek to change it. Members of the Senate Judiciary Committee have been given proposals by the administration, the Patriot Act and its revisions, after 9/11 to give new authority to the administration. Those provisions passed on a strong bipartisan vote. So my question is very straightforward. Is there anyone on the panel here who believes that the President did not violate the FISA law with the new wiretap program as he has described it?
I don't know what the new program is, Senator, and that's the reason...
If you could lean over a little closer to the microphone.
I'm sorry. I don't know what the new program is, Senator, and that's why I, in my prepared remarks and in my answers to other questions, I'm not in a position to offer any opinion about that. My understanding, and this is from what I've read in the lay press now, I understand, having read this, I believe in the Wall Street Journal, that some judges of the Foreign Intelligence Court, present judges, not any of us because we're not on it anymore, and certainly not me because I've been off it for, since 2001, some of the judges have been briefed on the program. I also understand from what I've read in the lay press and what I heard from Senator Feinstein a few moments ago that some senators have been briefed. So, but I don't know what the program is, so I'm not in a position to offer any comment at all about what the President's doing.
Well, as we've heard it described, and I have not been briefed either, there are only a few senators who have, it is the interception of domestic communications between people in the United States and those in foreign lands, and that strikes me as falling within the four corners of the FISA law as written.
Well, you used the word in your introductory question, and in that question, domestic. And as I understand from the lay press, again, this is international. It's not domestic. So that's why I'm not in a position to answer, sir.
You know, did the statute limit the president? It created a balance between them, and I don't think it took away the inherent authority that Judge Kornblum talked about. He didn't call it inherent. He doesn't like that. But the whole thing is that if in the course of collecting the foreign stuff, you're also picking up domestic stuff, which apparently is happening. I don't know it becomes a real question. You know, is he under his inherent power, or is he running around the statute? And you know, I had a great thought later when you asked the hypothetical about some FISA judge turning down the application on one of these warrantless programs. That could happen, but not if the court is allowed to sit in bank. My experience and knowledge of those judges, that's just not going to happen. But if they sit in bank where there's real problem or peril.
May I ask one last question? In the proposal by Senator Specter, under Section 702A, it states the FISA court shall have jurisdiction to issue an order under this title lasting not longer than 45 days that authorizes an electronic surveillance program. By passing this, would we be ceding authority to this court to authorize programs, electronic surveillance programs, currently not authorized under law?
It would be a different approach, certainly, wouldn't it, Alan?
The programs that are being used, of which I don't have any specific knowledge, are key to today's technology and to the terrorist organizations, wherever they may be. It's obvious, just as the years unfolded after 1978, that the intelligence threat changed. When we first started using FISA in 1978, the overwhelming number of targets were foreign governments, hypothetically, you know, say the evil empire and Eastern European bloc. However, as the world changed and the threat changed, so did the use of FISA. And by the time I left the FISA program, the balance between international terrorism and clandestine intelligence gathering as the basis for the surveillances had shifted dramatically to international terrorism. For example, the FBI has made international terrorism its number one priority, its number one objective. So if you authorize programs as opposed to surveillances of specific individuals or specific countries, it's undoubtedly true that over time the programs will have to change to meet whatever the intelligence needs of the country are.
I would just add that I think it goes without saying that every member of the Senate, that both sides of the table, would agree that we want to give this administration the authority it needs to keep America safe and intercept all communications necessary for that to happen. But we thought that we had established a legal process by which any president could use that authority with at least some court approval, carrying on a grand tradition in our country that no executive could act unilaterally. But I'm concerned, even in passing the Specter law, as to this, whether this president or future presidents would just ignore it and go back to a point made earlier, that a president, as you said earlier, would be remiss in surrendering his constitutional authority to a statute. If that is the case, then I wonder if, all of our efforts notwithstanding, the president can claim necessary and proper authority or whatever it might be and simply ignore what we've done. Thank you, Mr. Chairman.
Thank you very much, Senator Durbin. Pardon the interruptions from time to time. We're negotiating the immigration bill while this is in process, and we're concerned about a substitute being offered and the vitiating the order for a vote on cloture, and we have a lot of transactions we have to handle, so sometimes we're distracted a little bit, but I want to come back. But Senator Hatch has another commitment, so I'm going to yield to him at this point.
Well, thank you, Mr. Chairman. I appreciate that courtesy. I want to personally thank you all for being here. I think you've done a very good job of trying to explain to us these principles that you all deal with or have dealt with in the past. I am familiar with the program, and I have to say that I certainly agree with your proposition that the Congress cannot take away the President's power under Section 2 of the Constitution. And I would even make the argument that the President's program meets the Fourth Amendment requirements of reasonable cause. But to make a long story short, I think you've been very helpful to the committee here today, and it's meant a lot to me. As you know, I have a tremendous regard for the federal courts and for each of you. And I appreciate all the work you're doing. And I do think it's a good thing if we can comply with the FISA statute. But this current statute is not adequate to take care of the problems that currently exist. I appreciate the distinguished chairman and his efforts to try and come up with a statute that presidents will comply with or can comply with without taking away inherent powers, to use that term, that the president has under Article 2 or otherwise. Now, let me just ask one more question, and I appreciate the distinguished chairman giving me this opportunity. And again, I'll direct it to you, Judge Kornblum, and I would appreciate anything any of the rest of you tremendous judges would care to add. I'd just like some clarification on a few points based on your understanding of the law. If the government obtains information through the NSA program, do you believe as a matter of law that this information can be used in support of applications for a court order under the FISA statute? And do you believe that any fruit of the poisonous tree arguments are valid? In other words, if they actually obtain information that would support applications for a court order under the FISA statute, would the fruit of the poisonous tree arguments be valid against that information?
I think the answer to both questions is yes. As we did in the Ames case, we explained to the FISA court that Attorney General Reno had approved 6 warrantless searches of Ames' home and office at the CIA, and we did that in conjunction with the applications for continued electronic surveillance of Ames, because the FISA statute at that time didn't permit surreptitious searches. The court considered it and approved the electronic surveillances. Ames never went to trial. He decided to plead guilty rather than have his wife face imprisonment. If he had gone to trial, his attorney, Plato Kacharis, would undoubtedly have challenged all of the evidence obtained in the warrantless searches. My personal belief is that when I persuaded Attorney General Reno to authorize the warrantless searches, she was doing so lawfully under the Trong-Humphrey line of cases in the Fourth Circuit. And of course, Ames lived in Northern Virginia, which was in the Fourth Circuit. So you had a situation where, in the Ames case, you had warrantless warrantless physical searches approved by the Attorney General in full conformity with the law on that in the Eastern District of Virginia, and at the same time, you had FISA surveillances authorized by the FISA court. I think both would have been sustained, but there's an important difference between them. During the course of the trial, the FISA information, the FISA applications, would have been protected from discovery because FISA has that protective mechanism in it. Defense lawyers never get to see FISA applications. On the other hand, the warrantless searches authorized by Attorney General Reno would have been subject to full discovery. And whatever paperwork Attorney General Reno saw, what I had submitted to her, would have been subject to disclosure and used by the district court in the Eastern District of Virginia to determine whether the surveillances were lawfully authorized and conducted pursuant to the pre-FISA standard, even though it was conducted after FISA came into law, because
this is really an important point.
Because the warrantless search was not available to the government in the FISA statute. In the context of the present situation, the warrantless collections now being done by the President would be subject to the same discovery. That is, whatever legal mechanism was being authorized, was being followed to authorize the collection. If the President wanted to go forward with prosecution and use that evidence at trial, it would be subject to the federal rules of criminal procedure to the normal discovery. If the President...
So there would definitely be protections for individuals.
Well, you have the Classified Information Procedures Act to deal with that. And if the situation became unbearable, the President could always withdraw prosecution or exert the state secrets privilege to protect military...
In either event, that would be a protection of the person accused.
Yes. The State Secrets Act would, in effect, end the prosecution.
Sure.
But the federal rules of criminal procedure would protect any defendant charged with evidence collected in the program.
You mind, Mr. Chairman, if I ask just 2 more questions? I'd be happy.
Do I mind if you ask 2 more questions?
If you do, I won't.
I've already opened the door. Ask all the questions you want, Senator Hatch.
Oh, I'm just beginning then. No, I'm just kidding. I have 2 more. And please, any of the judges, other judges who care to comment, I'm not meaning to just make this a dialogue between the 2 of us, but...
You want 2 more questions and how many more answers?
Well, anybody who feels like they should, I'd be happy to listen to them. I'm sure you would too. Judge, do you believe that information obtained under the NSA program may be legally used in support of an application for a Title 18 warrant where you believe one of the parties has been determined to be an al-Qaeda affiliate but is a suspected common, or has not been determined to be an al-Qaeda affiliate but is a suspected common criminal, say such as a drug dealer?
Well, any determination like that, that is faced by a district judge in trial, is going to be decided under the federal rules of criminal procedure and the protective mechanisms of the Classified Information Procedures Act. There's no way to predict what the facts are, and a district judge would be faced with making that decision.
Well, under Senator Hatch's hypothetical, if one of the parties to the conversation is not al-Qaeda, that's outside of the President's purview. The Attorney General hasn't told us much, but he has told us that one of the persons, U.S. persons, one party to the conversation is in the United States and one is overseas, but at least one is al-Qaeda. So when Senator Hatch poses a hypothetical that neither is al-Qaeda, how could that be justified under the President's program?
Well, even if one is al-Qaeda, the foreigner calling into the country but talks to a common criminal, can that be used against the common criminal?
Well, you've changed the hypothetical now to make one al-Qaeda.
Okay. I kind of thought that was implied.
Well, whatever the facts are, the standard followed by the district judge is going to be that enunciated in the pre-FISA decisions.
Right.
That is...
In other words, the criminal will have some element of protection from a civil liberties standpoint.
I would think the answer is yes, that a district judge would protect his liberties, and he's going to be bound by the judicial decisions which define the President's power.
Well, how can the criminal have protection when the wall is down and the law is established that if you have a foreign intelligence warrant and incidental to that there is evidence of a crime, that it's usable? That's the current status of the law.
I'm talking about using the current warrantless surveillance.
You're talking about what, Senator?
Warrantless surveillance, the warrantless surveillance.
Well, to be admissible...
Let's see if we can bring this to a close, Judge Kornblum, if you'll answer this question.
To be admissible, the evidence would have had to been lawfully seized or lawfully obtained, and the standard that the district judge would use is that, depending upon where this is the law in his circuit. In most of the circuits, the law is clear that the President has the authority to do warrantless surveillance if it's to collect foreign intelligence and it's targeting foreign powers or agents. If the facts support that, then the district judge could make that finding and admit the evidence, just as they did in Trong-Humphrey.
Senator Hatch, I'm delighted to have a few comments, but we're now over 10 minutes, and we have another panel.
I'm happy to discontinue any further questions.
But before you leave, Senator Hatch, I want to cover one point in your presence, and that is you have been privileged to being briefed because you're on the subcommittee.
Right.
And when you say that you believe it is constitutional under the Fourth Amendment, I have a lot of respect for your legal judgment, and I was once an advocate for you for the Supreme Court. But under the doctrine of separation of powers, you are not a judge.
No, that's true, and I may very well be wrong.
Well, you may be right or you may be wrong. Judges are sometimes right and sometimes they're wrong.
Right.
But our system is that the judges make determination of constitutionality. Senators don't. Even super lawyer senators like you, Senator Hatch,
well,
you don't make decisions on constitutionality.
Oh, we make them every day. The problem is that they may not be worth the decision-making paper that we write them on.
No, I think they're very valuable, but it violates the principle of separation of powers. Senators are not judges, and to submit the program to the Intelligence Subcommittee, and in a context of the statute proposed to have 45 days of free rein for the administration, and then at the end of 45 days, if there is sufficient probable cause, going to the FISA court, but if there's not, to go to the subcommittee. I don't know exactly what the subcommittee does at that point.
Well, let me just say this much. The administration, rightly or wrongly, and that may have to be determined by the courts in the final analysis, the President decided that this program had to be reauthorized every 45 days, that the Chief Judge of the FISA court was informed, the next Chief Judge of the FISA court was informed, 8 top members of Congress were informed on the program, and the question is that enough information to be able to resolve the conflict in favor of the President's argument? It may take the courts to decide that, but I see plenty of concern here on the panel that you may not know yourselves how that should be decided at this particular point. The fact of the matter is that we've had people who have been hotly criticizing the President for doing what the President feels he had to do to protect our nation and to protect our people from terrorism that could amount to very serious consequences, even worse than 9/11. And these are very important issues. The distinguished chairman, of course, is trying to come up with a statute that the presidents will be happy to comply with, that will solve the problems and the deficiencies of the current 1978 FISA statute. I commend the chairman for that, and I'm certainly going to try and help him on that. And I commend all of you for being as cautious as you are on just how all of this is going to come down in the end. So, Mr. Chairman, I just want to thank you for allowing me to have this little extra time. I know I've taken more than I should have, but I just want to, again, express my respect for all of you and what you've had to say here.
Well, let me make one more comment, Senator Hatch, before you go.
Sure.
And that is that if there is an order by the FISA court that the president feels is wrong and needs to act against, he can get a supersedious. I'm going to ask that question, but we all know that he can get a supersedious until there is an appeal. It's discretionary with the FISA court, but you would expect in an emergency situation there'd be a supersedious. And then you have an appellate court for FISA. And then if you don't like what the appellate court does, you can get another supersedious and go to the Supreme Court. But when the court has ruled, if I understood Judge Kornblum correctly, the president can't disregard it. When the court makes a determination on constitutionality and you go up the line and you get to the Supreme Court, that's that. Don't you agree, Judge Kornblum?
Yes, I do.
That's Marbury versus Madison, 1803. Been followed once or twice. Well, I'm going to go on to some other lines of questioning, Senator Hatch.
Well, just one last point on that. Judge,
I doubt it, but go ahead.
Judge Kornblum also indicated that the president may be faced with a situation because of time constraints and so forth. That isn't just a yes here, where he may have to just act in the best interest of the country. That may be upheld by the courts, it may not be. I don't know. And neither does anybody else here today. But I'll tell you one thing. I want my president acting, as long as it's clear that they've done everything they can to comply with the law, and where they feel that they have this obligation under Article 2 of the Constitution, I would want my president to protect us. Well, I think that's the position they've taken down there, rightly or wrongly. I personally believe rightly.
Well, when you say act, you customarily mean some response if the country's in jeopardy, and of course the president should act. That's right. If you're talking about gathering additional intelligence, the president can do that too, and he has 72 hours to go to the court. And if he has acted in a way that the court later says is illegal, he's gotten the information. He's acted, and he has that authority under an emergency situation. Okay.
All I can say is it's a little bit different in this situation with what I know about it.
Well, Senator Hatch, would you be willing to be a witness so we can really find out what's going on here?
I think that's what I've been maybe doing. I don't know. I apologize to the chairman.
Judge Brotman, we ended up on my first round with your being interrupted on responding to the question as to Judge Keenan, and then to reconstruct the question, it's in a context of the modern technology and the changes since 1978 when the Foreign Intelligence Surveillance Act was passed. Do you think that the legislation which I've proposed will be a good balance to protect civil liberties and give the executive sufficient authority to protect the country?
Well, I do, because if you look back over the years, the court has reacted to these changes. And we have met, we've discussed new methods, new equipment. We've seen them, they've talked to them about us, they've talked to us about them. We've been able to have a colloquy going back and forth, and in instances we have agreed on a methodology of presenting the application within the language that was currently in the FISA statute.
When
I mean, everything, you can't keep coming back and forth all the time, but in the course of drafting something, and this is the Congress's function, in the course of drafting something, the language has to be sufficient to cover.
When Senator Hatch was asking questions, hypothetical questions about obtaining information from the administration's program and then using it in the context of an application for a warrant from the FISA court, there's an issue as to whether the judge to whom the application goes knows what the program is. We know that President Judge Lambert, or we hear that President Judge Lambert was briefed on the program. We hear that President Judge Kohler-Catelli has been briefed on the program. But we don't know about the other judges. We know that Judge Robertson resigned. And the inference is because he didn't know about the program and wasn't going to be a party to being on the court when there was a program in effect that he didn't know about. It's really very regrettable that we have to speculate about anything. And that's why it seems to me that when you have a court where you have expertise and you have the ability to keep a secret, that the program ought to be submitted to the court. Now, Senator Hatch is right that it's constitutional, then there oughtn't to be any hesitancy. And when the court makes a ruling, and the appellate court makes a ruling, and then the Supreme Court makes a ruling, that's that under our society. That's how we decide that we're a nation of laws. And we do need to protect the country. And the President has very vast authority under Article 2. There's no doubt about that. But as you've all testified to, that's ultimately a judicial determination. It's Rockbed Americana. It's Marbury versus Madison. We're going to take a very short break before the next panel, which will be heard more quickly since there won't be too many rounds of questioning. But I want to thank the judges for being here. We'll take just a recess for a minute or two.
Does that finish us? I think so. I think so. Anything, other information I can give you or help you? I'll be glad to. Give you a call. Okay. That's why we pushed them up front.
The committee will resume. Our next witness is Mr. Morton Halpern, who's Senior Fellow for the Center for American Progress and Executive Director of the Open Society Policy Center, a bachelor's from Columbia, PhD in International Relations from Yale, served in both the Johnson and Nixon administrations in key positions. Served as the director of the Washington office of the American Civil Liberties Union, consultant to the Secretary of Defense, in 1993. That would be the Clinton administration. I thank you very much for joining us, Mr. Halpern, and thank you for your patience if you've been patient.
Yes. Well,
we welcome you here and look forward to your testimony.
Thank you very much, Senator. I appreciate the opportunity, and I appreciate very much the efforts that you have made to try to bring this program under FISA and to reestablish the system that I think has worked very well, and as we heard from the judges, has permitted the intelligence agencies to gather the information that we need. And I agree with you that it's critical that we find a way to bring what needs to be done under congressional authorization and judicial review. But I also think, as you've suggested, that Congress can't legislate in the dark. We don't know what the program is, and therefore it's not possible to tell whether your legislation, even if it were enacted, would actually authorize what the administration is now doing. And I just think it's a fundamental mistake for Congress to legislate in this area before it's had a full investigation and knows what is being done, and before the administration states what it needs in order to carry on the surveillance that he thinks it is necessary.
Since I'm the only senator present, Mr. Halpern, I'm going to vary our procedure and ask you a question on the point you've just made. In terms of knowing the program, my legislation provides for knowledge of the program to the FISA court. Why isn't that sufficient?
Because the problem, Senator, is that you don't just try to find a mechanism, which I think would be difficult to do, to say the administration's current program with the current congressional authorization should be reviewed by the court. Your bill actually authorizes a program with a standard requiring the Attorney General to make a certification to the court that certain factual predicates have been met.
Well, I disagree with you that we're authorizing the program. We're authorizing the FISA court to review the program.
But you're authorizing, with respect, Senator, as I read your bill, you're authorizing the FISA court to issue a warrant for the program if it meets the standard, if the Attorney General certifies to the court that it's met the standard laid out in your legislation.
Well,
so if
reread my bill, and so will I.
Yeah.
That's not what is intended. What is intended here, and I think the statute provides what I've intended, and that is for the. We're not taking the Attorney General certification. We're not going to do that. We're going to require that the administration inform the FISA court fully what the program is, and then the FISA court's going to make a determination whether it's constitutional.
Yeah. Well, Senator,
how about that? If the language satisfies you,
I think the problem with that is whether the FISA court could actually make a ruling. That is, whether there's a case or controversy, since the administration is not asking for a warrant. But if you wanted to enact a bill that said President cannot conduct any surveillance except if it gets a warrant from the FISA court, and it needs to go to the FISA court to see whether the court will give it a warrant for this program, I'm not sure that that's constitutional because you don't have a specific case or controversy.
Well,
but that is not what I think the bill as drafted, as I read it, does.
We've gone into the issue of advisory opinion, and we did it here again today, and we did it with a panel of experts. It's the same analogy. There's no case in controversy when the FBI goes to the FISA court and wants a warrant. It's an ex parte proceeding, and there's no case in controversy. And this is the analogy, which there's good legal authority, is not advisory, and is not in violation of the case in controversy rule.
Well, and that may be, and the court would obviously decide that, and I think that's the appropriate place to decide that. But I think it's essential, if that's what your intention is, that the not draft language, which the court may well interpret as authorizing the program. For example, we know the argument that's now going on about the military tribunals is that the Congress, by providing for judicial review of the military tribunals in the Court of Appeals, the government is arguing, is therefore authorized the military tribunals. The government would certainly argue, based on your legislation, that you had authorized a program and authorize the court to grant a warrant for the program if it meets the standards set out in your
The
legislation.
government could argue most anything under any circumstance.
No, but
we'll take a look at it, and if you're correct, we'll redraft.
Okay, well, I appreciate that, Senator. I mean, the critical section of your bill that deals, specifically with that issue is Section 703A7, which, as I read it, says that the Attorney General needs to certify that the program involves listening to agents of a foreign power or persons in communication with a foreign power where those persons have attempted to engage in terrorist activity. And that I read as an authorization of a program. The attorney, let me suggest an alternative way that it seems to me that Congress might proceed here, which is to say the Attorney General in his testimony before this committee was pressed very hard by Senators.
Mr. Halpern, let me set the clock back for you for 4 minutes, and
okay.
we'll hear you. Senator Biden has arrived. So with other members present, I will not proceed informally. We'll set it at 4 minutes, and
okay.
The floor is yours, and then we'll move on to Mr. Chris, and then we'll go to rounds of questioning.
My view is that the Congress first, as I said, needs to have a full investigation so that it knows what's going on. Second, I think it needs to insist that if it grants new authority to the President, that the President will agree to abide by that authority and again operate within FISA. Because there's no point in establishing a new procedure if the President takes the position that he's not bound by that new authority, as you gave him new authority in the Patriot Act, but is simply going to engage in whatever additional programs he wants. And I suggest in my bill some statutory changes in the language dealing with criminal penalties and civil penalties and the cooperation of the telephone companies, which would make it absolutely clear, although I think it's unambiguous as Congress drafted it, that Congress intended that there'd be protection from civil or criminal penalties and a requirement by the phone companies to cooperate only if the surveillance is pursuant to FISA or Title III if it's a criminal case. I also think that you should focus on what the Attorney General has identified as the problem. And in his testimony before this committee, when pressed very hard by senators on both sides as to why FISA was not sufficient, the Attorney General gave only one example. He said, in an emergency situation, NSA officials do not have the time to get to the Attorney General to get him to authorize an emergency surveillance. And that is, I think, a correct reading of the statute. So what I would urge you to consider is to, in effect, grant him an additional 72 hours so that the Attorney General can establish a procedure under which the NSA officials can authorize a surveillance in an emergency. They have 3 days to get to the Attorney General. If he agrees that, as he puts it, there is reasonable belief that the target is an al-Qaeda person, that he can then authorize an additional 3 days of emergency surveillance, and then he can go to the FISA court and get a warrant. That seems to me to satisfy the problem that the Attorney General has identified. And if the administration wants to come up and identify another problem, then I think the Congress needs to consider that other problem as well, and assuming that it's constitutional, find a way to fix that problem. But I think to try to legislate a solution where the administration has not identified a problem that needs to be fixed simply will not solve the problem, which is that the administration is moving ahead without getting FISA warrants. So that, as you recall, Senator, one of the reasons that we got FISA, and I think it's been alluded to before, is that the telephone companies were saying that they wanted clear guidance. And I think administration officials in the FBI and NSA were saying they wanted clear guidance. And I think that clear guidance is essential because otherwise you put FBI agents, NSA agents, and private individuals in jeopardy of civil or criminal penalties if the president is acting not pursuant to the statutory scheme. And you also get leaks. I think it is not an accident that we got leaks before FISA was enacted because people thought the presidents were ordering wiretaps when they should not have done so in both Democratic and Republican administrations. And we got leaks of this program because people thought that the president was acting outside the law. As far as I'm aware, there has not been a single leak of a program authorized under FISA. And I think that's because if people in the government are confident that what is being done is constitutional and following the law as Congress has laid it out, then they don't leak it. And therefore, I think it's essential to bring this program under those procedures. Thank you.
Well, thank you very much, Mr. Halpern. We turn now to Mr. David Chris, who's Senior Vice President, Deputy General Counsel, and Chief Ethics and Compliance Officer at Time Warner. A graduate of Haverford College, law degree from Harvard, served as a law clerk to Judge Trott of the Ninth Circuit, was a special assistant for the U.S. Attorney in the District of Columbia, and has had a variety of positions in the Department of Justice. Thank you for joining us, Mr. Chris, and we look forward to your testimony.
Thank you, Senator Specter. Thank you for inviting me to testify. I am appearing here only in my individual capacity and not as a representative of any current or former employer. On the legal issues raised here, I think I'm exactly where you are. I believe that the NSA surveillance program violates the Foreign Intelligence Surveillance Act. I don't believe it's permitted under the authorization to use military force, and I don't know whether it's within the scope of the President's Commander-in-Chief powers because I don't possess the relevant facts. I was not read into this program at DOJ, and I have no classified information about its function or its operation. Because of the way I analyze those legal issues, I see this as a constitutional moment. I see it as a clash between the expressed will of Congress and the actions of the President. And even if those actions are indeed constitutionally authorized, as they may be, it's not a very appealing state of affairs, at least for the long run. And so for that reason, I think it is very wise to consider legislation that would authorize and regulate the NSA surveillance program or something like it. Having said that, I don't know whether legislation actually should be enacted, and if it is to be enacted, I don't know exactly what it should say, because I think factual ignorance is an impediment, not only to legal analysis, but also to legislative drafting. I have to admit that I spent the weekend on legislative drafting, and the result is in my written testimony that I submitted yesterday. I tried in my draft to follow your lead, to use your bill as a model, and also to stick to three basic principles. First, wherever possible, to use existing language and structures from FISA. I think that will promote a more seamless integration of any new law into the old, and it will import into the new law the settled understandings of the terms that are used. Second, I think, like Mr. Halpern, I believe it is appropriate to accommodate the government's needs to the extent that they should be, but I would not go beyond those articulated needs, at least without knowing what the facts are. And third, and finally, most important for somebody like me on the outside, try to provide something that will be a useful vehicle for discussion and debate. And my draft is really designed to be modular, almost like Lego. You can snap individual policy pieces in and out according to your preferences without disturbing the underlying structure. So the goal was really not so much to stake out a strong policy position on any of these issues, but just to tee them up cleanly for your resolution. One of the key issues that we heard discussed this morning concerns the role of judges. Senator Specter, as I understand your bill, it would require the FISA court to review not only individual instances of electronic surveillance involving particular targets and facilities, as is the case now, but these electronic surveillance programs writ large. I think that judicial review of that type has a number of advantages to recommend it. Among them, that I think it would increase the public's confidence in and acceptance of the surveillance. Now, it raises a couple of constitutional questions, but as laid out in my written testimony, I don't know the answer to those questions, and I don't say that they will be ultimately a problem. And it may or may not be acceptable in the end to a lawmaking majority. That's obviously something that's beyond my ken. I do think, however, that your bill is an excellent, concrete, and specific vehicle for extended debate, which I assume will ensue. I've tried in my written submission, and I'll try today to contribute to that debate, and I hope you find it helpful. Thank you.
Thank you very much, Mr. Chris. We appreciate your suggestions on drafting. We are open. Appreciate what Mr. Halpern said earlier. We'll read and reread and look for the bill as I have described it. Both of you have talked about an investigation so we know what the facts are before we legislate, and that's a pretty good idea generally. The President says that Congress leaks, and regrettably that's true. The White House also leaks, and I wouldn't want to get involved in which institution leaks the most. But we do know that the court has maintained confidentiality, and that's why not knowing what the program is, I come to the conclusion that you can structure a statute where the administration cannot claim refusal to turn over the program, disclose the facts, because of concern that there will be a leak or an inappropriate disclosure. Mr. Chris, you say that you have identified constitutional questions and you don't know what the answers are. You have a firm resume as a lawyer. Are you concerned about the advisory opinion issue, or would you accept the analogy on the ex parte application for a warrant to be the same as, in effect, an ex parte application for approval of a program?
Yeah, it's interesting. In thinking about this, I actually found, with the assistance of a former colleague, an opinion of the Office of Legal Counsel from about 1978 that discussed whether the original version of FISA satisfied the case or controversy requirement. And it made an argument that it did, and I assume that's why the legislation was enacted. I think much of the reasoning in that opinion would apply to programmatic judicial review as well as individual judicial review. I'm just not sure that all of it would, or exactly what the differences would be. I don't mean to sort of be overly tentative, but I've only been thinking about this issue for about 72 hours, and I'm just not quite sure. I assume somebody, OLC or somebody else, can take a really hard look at it. Maybe you already have, maybe this panel of experts that you had before have already thought through it, in which case that's fine. I really just thought I should flag the issue. I see that it was already flagged, and so I didn't need to.
Well, we have taken a hard look at it, and we've questioned experts. We had some testimony about it this morning, again, that it does not violate the advisory opinion doctrine, so that we think we're on solid ground. Mr. Halpern, let me come back to pursue the discussion which you and I had a few moments ago, and that is if you accept a statute which I described, and that is that Congress would authorize the FISA court to review the administration's program and make a determination of constitutionality, not authorizing the program as you are concerned about, and I can understand that. I don't intend to authorize the program. I don't know what the program is. I'm not about to authorize a program. But I'd like to have somebody find out what the program is and make a determination. And that's a judicial function. In my opinion, it's not the function of the subcommittee on the Intelligence Committee.
I certainly agree with that, Senator.
You agree with? Well, I'm glad we found something to agree.
No, I agree. I mean, I agree with all your comments on the other bill. I think they have those very serious, that they're relying on the Congress to do a judicial function, and that's inappropriate. I would say, if you're going to go down that route, you need to find a way to require the President to submit the program to the FISA court. And I think the only way to do that is to amend FISA and the authorization to use military force to reinforce what I think is already in the bills, but the administration doesn't, that these are the sole and exclusive means that Congress intends to go forward, and that nobody is safe from civil or criminal penalties, and the phone companies are not directed to cooperate unless the program is consistent with FISA.
Well, we can legislate. We can pass the bill. The President has the authority, obviously, to veto it, and we can pass it over his veto. And if it comes to that, then we would have authorized the FISA court to examine the program. That's as far as we can go.
But the President, the FISA court, I think, even under your theory, can't examine it unless the President brings it there. And there's nothing in what the administration has said.
If the legislation says the President must bring it there,
not if the President says that in whatever, beyond whatever, as I understand the administration's position, it is beyond whatever Congress says. It has the authority that Congress cannot limit in any way to conduct warrantless surveillance whenever it believes it needs to do so. So the first step, I think, has to be either to get the administration to concede that if it gets the appropriate authority, it will follow the legislative rules, or to find a way to compel it to do so. And I think, as I understand its position, even if you pass this bill over its veto, it would still say that's fine, but we're not bringing any program to the FISA court. And
my time is up, and I believe in observing the time.
Keep going. No.
No.
Like two of us.
No. I'm going to observe the
Believe
time.
in getting ideas out. Keep going. Take some of my time.
You want to take less than 5 minutes, Senator Biden?
Take less than 5 minutes, and I'll take 5 in my second round.
It may be easier to deal with the administration than Senator Biden.
We'd be a lot better off if you were dealing with me instead of the administration.
I'm just going to make a concluding comment. I think there'd be a political solution if Congress passed this bill over the President's veto. It'd be like the torture issue, where when we had it 89-9, the President accommodated to it. And of course, there's always a loose end, whatever we do around here. As Secretary of State Schultz said, nothing is ever settled in Washington. And we have the signing statement, which takes away, perhaps, or arguably, we're going to have a hearing on that as to with the signing authority. Not that what we decide on signing authority will bind the President either, but I think there would be a political answer. But if we pass a bill and we pass it over the President's veto, I think there'd be a political solution. But as they said in the song Kansas City, we have gone as far as we can go. And that's as far as this Judiciary Committee can go in pushing legislation for the Congress. Senator Biden.
Thank you, Mr. Chairman. I'm not sure of this, but I think it was Professor Corwin who said the Constitution, this was a little more than an invitation for the Congress and the President to do battle, I'm paraphrasing, over the conduct of foreign affairs. And we've retreated from the battlefield. This is a constitutional moment. This administration has virtually no credibility. And here we are, not the chairman's bill is a solid bill, but here we are as a Congress as a whole, just refusing to engage in that contest. I think if anybody gets censored, it should be the Intelligence Committee for failing to do its responsibility. I'm serious about that. I think this idea of censoring the President at this point, we don't know what he did. I mean, Mr. Kirk, or Chris, excuse me, your phrase, if I can find it here, is that it is difficult to analyze a surveillance program and almost impossible to comment on legislation to regulate such a program without knowing the facts. You have Stuart Taylor, which I think is kind of interesting, a well-respected commentator and news person, saying the following. He's saying that the administration argument about the not tipping our hand to terrorists by telling the Intelligence Committee because no oversight is appropriate, and he quotes and he says, it's utterly unpersuasive and rather alarming. Carried to his logical conclusion, he would argue that ending all congressional oversight and censoring the media coverage of all sensitive intelligence defense activities. That's it, in a nutshell. Flat out. What are we doing here? What are we doing here? And we're talking about the courts. You know, there's a third branch of government called the Congress. And the idea that I'm going to delegate to the courts as well as the administration something as fundamental to the security of my country to make a substantive judgment of whether what they're doing makes sense. Not merely whether it's legal. Does it make sense? Does it make sense? What have we become? What has happened to the notion that this is something that the people have a right to have an input on? It's bizarre. It's absolutely bizarre. Now, I agree with the senator. He's being practical. He's being practical about this. We have a judiciary. Look, I was there when we wrote FISA. I was on the Intelligence Committee and on the Foreign Relations Committee. Somebody tell me that the risk of leakage at the time we were talking about the location of SS-18 Soviet mobile missiles that the Soviets were in the process of pursuing, and all the intelligence that we're engaged in around the world, that it was less dangerous then than it is today? Nothing got leaked. We held a year of oversight hearings, roughly. And then the Judiciary Committee, which I was also a member of, interfaced with the Intelligence Committee when we came up with a thing called FISA. So what I find absolutely amazing here is that we are essentially, in this constitutional moment, being required to say, it's really not practical. There's not practically much we can do. Not practical. We don't have. Here's my question. Does anybody think? Are either of you convinced that the Attorney General knows the extent of the program? What do you think? I am not being facetious. I asked him the question under oath. He was here. And I asked him the question, Mr. Chairman, can you assure us the program you described is the only program that exists? And if my recollection is correct, he said no. Well, I don't even believe the Attorney General of the United States of America knows the extent of this surveillance program. And I find it breathtaking that the arrogance of this administration, concluding that a group of people we don't even know, they do not name them, they will not tell us who they are, they are supposedly, quote, experts on terror, making judgments on the spot, as explained to us, as to upon whom to eavesdrop. And then no assurance or any program demonstrating how they mitigate information that they've gathered. This is like Alice in Wonderland. This is like Alice in Wonderland. And then this malarkey about, well, you know, if you raise questions about this, you want to support the terrorist. So, do you think the Attorney General of the United States, do either of you think he knows the full extent of this program?
He certainly, I mean, he certainly doesn't, because he was asked questions like, who is it in NSA that can authorize this? And that question he actually answered and said he didn't know. So I think it's clear that he doesn't know. It's also, I think, clear if you look at the cases that authorized warrantless electronic surveillance prior to the enactment of FISA, and the Ames case that the administration likes to talk about so much, they all turned in part on the fact that these were personal judgments by the Attorney General of the United States. There is no case that suggests that a nameless NSA official who's not confirmed by the Congress has the authority to make a determination of a warrantless surveillance of a United States person. So at the very least, I think there's a statutory infirmity there. But I think that the Congress has to act, in my view, on what the Attorney General said. He said, here's a specific problem. I think the Congress could react to that specific problem. But I think it would be a mistake to try to guess. And Senator, if I may, Section 704(3) of your bill says that the FISA court shall issue an ex parte order if it finds that there's probable cause, and then it lays out a standard of probable cause of what. That's a new standard that doesn't appear in FISA. And as I read it, as I say, that is an authorization to the FISA court to conduct surveillance under that standard. And none of us have any idea whether that standard is what the administration is using on this program. And that's That's the concern I have, that the bill is in authorization.
One more question. In full disclosure, I'm one of those unnamed congressional officers you referred to, who've been talking to you about this legislation. Is there a way that would make sense, not for the purpose of compromise, but for the purpose of being more comprehensive? Is there a way of marrying and or dealing with both the approach of giving the Attorney General what he says is the only impediment that he named was that he is just effectively inundated and you don't have time to make these judgments, by extending the time available to the Attorney General's office, and the approach that the chairman is pursuing?
Yeah, I think there is. I mean, as I now understand the chairman's approach, it is to try to find a constitutional way to bring before the FISA court the president's program as a program not authorized by Congress, and to let the court make a judgment about whether that's constitutional or not. I think the press report suggests the court has already done that. That is, that the court, according to the press, told the administration not to bring warrants for FISA surveillance based on this program. And that's another way, of course, that the FISA court does make this judgment. If they have in fact told the administration, I don't know whether that's true, it's certainly been reported in the press. But I think you also have to find a way to compel the president to do it, and I suggest in my testimony, by rewriting those provisions so that you send a clear message to the telephone companies that whatever authorization the Attorney General, certification the Attorney General's given them, isn't worth anything unless it's pursuant to a FISA warrant or the exceptions that are actually in FISA for emergencies. I think if you did those two things, coupled with a sunset provision and a requirement for a full investigation, that this would be a way to move it forward. So I would think it should be possible to merge these two approaches, and I would hope that you would look at that.
Let me conclude by saying, Mr. Chairman, I truly appreciate your willingness not to let this issue just go away. No one else, nobody else in the Congress with any authority is doing anything constructive. Nobody but you. You are the sole source of any constructive attempt to deal with this problem. And so please do not read my frustration as anything having to do with my frustration with you. It is not. And I understand that the truth of the assertion that the only thing that's going to change this administration's mind is a political judgment reached by the United States Congress and confronting the president, where he politically concludes it is not in his interest to continue to pursue the avenue he's on without any consultation with anybody. And so you're right on the practical and probably right on the substance as well. What frustrates me, I never thought I'd sit here after 33 years, from Richard Nixon to this guy, to President Bush, and find ourselves in the posture where we are literally paralyzed from having any notion, about having any idea. And I'm supposed to accept, and others are accept the word of Dick Cheney, accept the word of the president? Trust me? Trust me? Thank you for the time, Mr. Chairman.
Well, thank you, Senator Biden, and thank you, Mr. Halpern and Mr. Chris. Senator Biden, I intend to pursue this matter.
I know you do, and I'd like to work with you in pursuing it.
I intend to bring this bill up on the executive calendar on Thursday, and Senator DeWine's bill at the same time. And I want to vote these bills out of committee, and I'm going to press the majority leader to list them for argument in the Senate and move ahead. The testimony we had today was powerful. We had 5 judges testify, 4 former judges of the Foreign Intelligence Surveillance Court testify that this bill is an appropriate way to determine constitutionality of the program, that they talk about probable cause, and they talk about minimization, and they are experienced. Judge James Robertson, the judge who resigned from the FISA court, submitted a letter which I read the key part into the record. And in addition, Magistrate Judge Kornblum, who has been involved in 10,000 applications under the FISA statute, very extensive experience going back to your work, Senator Biden, back in 1978. And their testimony is powerful, 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 in my opinion. And we've given the administration a chance to be heard, the Attorney General. We invited them to come into this hearing today. And we've had 3 hearings in 22 days, which is pretty good for this committee. We heard the Attorney General on March the 6th. And we had a panel of experts in the interim in this hearing today, and we're going to mark it up. And we're going to bring it to the floor of the United States Senate. And there is no question about the fact that the tradition in this country is to have judicial review before there is an electronic surveillance. No question about that. And the Foreign Intelligence Surveillance Act gave exclusive authority to the FISA court. And I understand constitutional law that if the president has power under Article 2, it trumps the statute. Now I want to see a determination made as to whether looking at the program from the judiciary, it is constitutional. And Congress can't do more than pass a law or exert political pressure, and this is the avenue. And we're spawning a censure motion, and there's no showing that the president acted in bad faith, and he may well have the constitutional authority. We can't determine that. And I wanted to add a panel here today, Senator Biden, because this issue bears on the censure motion, and I asked Senator Feingold to be prepared to have a panel today, and he demurred. He was in Iraq. We had a long hearing yesterday on immigration, and he was in town to vote, but he wasn't in town for the Judiciary Committee meeting. And I've scheduled a hearing for Friday, and he wants it postponed, and I've got a letter, and as soon as I get back to my office, I've been engaged in this since 8:30 this morning, I'm going to say no. And I'm going to put that on the calendar for Thursday. If there's didn't want a hearing, next week we're going to be on the immigration bill. When we come back after the Easter recess, we have many hearings under reauthorization of the Voting Rights Act. And the orderly processing of the Judiciary Committee is something the chairman has to determine. I know you'd agree with that, Senator Biden, because you were the chairman, and you ran a good committee. You were the chairman from 1987 to 1995. 94 election changed that.
So happy you're the chairman now and not me. I'm delighted.
Well, I'm happy too. But I want to deal with the censure motion. We had Senator Feingold went to the Senate floor and got unanimous consent for 25 minutes to speak on it, and I knew he was going to be there, so I got 25 minutes, and after he berated the president for 25 minutes, I wanted to have a discussion with him about it. And he left the chamber after I asked him to stay, and sent Mike O'Neill, my general counsel, after him. I thought that after 25 minutes of berating the president, there ought to be some discussion about it. And I know that's not reasonable, but that's what I thought. So I took my 25 minutes ex parte. But there will be a day when we'll be in the same room discussing the matter. But I think today's hearing advances the ball. How much advances the ball, nobody can tell. But the ball is being advanced. The ball is moving forward. And I appreciate your testimony today. The endorsement by Mr. Christ and the qualified endorsement by Mr. Halpern. And thank you for coming, Senator Biden, and that concludes our hearing.
Thank you.
And you can see Senator Specter, the chairman, and the ranking member there, Senator Joseph Biden, having a chat as they've wrapped up this Senate Judiciary Committee hearing. We're waiting to bring you an audio feed from the Supreme Court. We expect that momentarily. Oral argument heard today on the legality of the president's use of military tribunals to try detainees and suspected terrorists. A driver for Osama bin Laden being held in Guantanamo Bay, Cuba, and that driver challenging his detention and trial. Those arguments wrapped up a short while ago, and as soon as the Supreme Court feeds the audio of that, we will have that for you right here on C-SPAN 3. You can also hear it on C-SPAN Radio. And again, you can see this hearing is wrapped up. We're waiting for the audio feed from the Supreme Court. The Supreme Court hearing today, oral argument in that case of Osama bin Laden's former driver, who's being held in Guantanamo Bay, Cuba, and challenging the legality, the constitutionality of his detention and trial. As soon as we get that feed from the Supreme Court of oral arguments, we will bring it to you here on C-SPAN 3, also on C-SPAN Radio, and you can follow on our website, cspan.org. House back today from a week-long recess. They're going to come in about 2 o'clock Eastern and take up about a dozen suspension bills. The Senate is in today as well. They've been working today. Well, actually, right now they're at their weekly policy lunches. Then they're expecting a cloture vote, a vote to limit debate on a motion to proceed to the immigration bill. We expect that shortly after 2 o'clock. Also, some work on lobbying overhaul in the Senate today. Tonight